Morning, Mr. Novak. You can start.
This morning, I propose to address you on 4 issues. First, the Article 59A issue. Second, Article 18.2. Third, the cross-appeal in relation to the date. The majority of my submissions this morning in relation to that first issue then, Article 59A, pause, scope of the appeal, grounds of appeal, which as Volume A, Tab 2 of the appeal bundle. Grounds of appeal are narrow in scope. They raise 3 issues. First, the objective, the misdirection in law, the objective test issue. And coupled with that, criticism and the judge characterised the required to satisfy Article 59. Scope of that first ground of appeal. Second ground of appeal is what is described as the unjustified departure from what the appellants characterise as the rule in Brando. Third,
I think principle rather than rule.
I mean, why I'm going scope of the appeal is. Beyond the grounds of appeal and certainly the third ground of appeal is this issue of again, it's a narrow ground of appeal because what is said is...
Sorry, Melanie, for instance, list out paragraph C, the second ground, which is the failure to consider matters in a run.
With respect, I was coming on to the third ground. And as I said, the third ground is... ground was a criticism that the judge considered the asserted misconduct grounds of appeal. Also, the fourth point, grounds of appeal, but is raised. Observed that in this case the respondent only has sought to uphold the judgment. Also put in a respondent's notice, hold the decision on wider grounds. Pressed on the respondent's notice. Addressing those 4, what I say are the 4 issues raised by the grounds of appeal and response. I'd like to make 3 preliminary. Second and third observations are going to be a bit detailed. If I could start with the first observation. This, as I think I've already foreshadowed, is that many of the submissions heard yesterday do go beyond the scope of those 3 grounds of appeal. Certainly the emphasis of my learned friend's submissions yesterday are somewhat different to those grounds of appeal. But we spent almost the first 45 minutes looking at the status of the shareholders and cooperation agreement, grounds of appeal, and criticisms that the judge didn't make findings. Criticism that the judge didn't make findings about a number of other matters. There's no fact in relation to a number of the issues that were criticised yesterday. Where the advocates didn't appear below. Very easy to criticise a judge for not addressing various matters in circumstances where either those weren't raised below or same emphasis.
What was clause 9.2 raised below?
My Lord, my learned friend took you to the skeleton argument where it is recited. As it is recited. Friend sought to put on it yesterday. My reading, it was not raised in the same way with the same emphasis. But more importantly, I'll come on to show you the significance of clause 9.2. And this really rolls into my second observation, which is this, and I propose to make good this second observation. That really, the reliance on clause 9.2 and the second was the central premise of his submission yesterday.
48 of what?
48 of the judgment. First sentence, not the second sentence. How do I accept sentence? My submission, that is an attempt to go behind the judge's findings of fact that the claimant's communications regarding the accounts, those are the communications with PwC, management...
Sorry, when you say the third sentence now...
First sentence. First sentence of paragraph 48. Oh, sorry, I should have added, there are two paragraphs 48. Over company product heading.
So which one are we looking
The
at?
one above company property. That was the sentence that my learned friend focused on yesterday. And in my submission, that central premise which I'll develop was an attempt to go behind the judge's findings of fact that the claimant's communications with PwC, with Mr. Lemaire, with the accounting team, was carried out transparently and in good faith. So you've got an express finding in relation to the accounts, in relation to his communications regarding those accounts, acted in good faith. So irrespective of clause 9.2, have a finding of fact there that's not been appealed.
Paragraph 46, is it?
Well, so it's... First of all, it's the second sentence of paragraph 48. But as I hope to show you in due course, my learned friend focused on one sentence in a section containing 6 paragraphs. And when you read the previous 6 paragraphs, it is clear. I rely not just on the second sentence. I'm supposed to go through paragraph by paragraph, so I'm not doing it selectively. My submission, it is clear that the judge found that the claimant acted in good faith That's just to headline at the moment, though. That's my second observation, which I'm going to develop in due course.
Does he actually use that expression? He uses the expression transparent, certainly, but does use good faith, does he?
Paragraphs, you see at the top of the page. Transparently.
Yeah.
Sorry, I've lost you above the paragraph above 46. 46 itself, sorry. Okay.
I say I'm going to take you paragraph by paragraph. But as I say, at the moment I'm just headlining the second observation. I'm going to address it in detail because it's central to my learned friend's. Third point, though, just to flag the third preliminary observation, is that my learned friend's submissions involve an artificial examination of the claimant's conduct on the 11th of February in isolation and without reference to the trial judge's findings that the employer in this case acted arbitrarily and unreasonably, both in the run-up to the 11th of February and on the 11th of February. As the trial judge found, those findings, the employer's conduct, but highly relevant when considering both stages of the Article 59A question. But you'll recall that you didn't hear once yesterday any attempt to address or deal with or refer to trial judge's findings of fact about the employer's conduct. Those points are raised fairly and squarely in both our skeleton argument and our supplementary skeleton argument.
Trying to say that we should measure the reasonableness, good faith of the appellant's conduct as a reaction to
first, the seriousness. As I set out in my skeleton argument, Brando, you heard to in our skeleton argument, Brando is authority for that proposition. But again, and this is all part of my third, will be part of this third preliminary. The question there is, what would the reasonable employer have done? And of course, there you've got a bit of a conundrum, because where the judge has found that the employer has acted arbitrarily, his words, arbitrarily, haphazardly, and unreasonably, then when you're positing the hypothetical reason employer, you've got a bit of a conundrum there. As I say, I propose to address that in that third headline, that third preliminary observation. Those are the three preliminary observations. I don't propose at this stage to go that first preliminary observation. I'll be coming back. But this second point about the first sentence of paragraph 48, address now and in some detail. The central premise of the appellant's submissions yesterday was based on the repeated assertion that the claimant had in bad faith proposed the inflation of the 2013 accounts for personal gain. As I say, to summarise, as I hope to demonstrate, that central premise, that central proposition, seeks to go behind the judge's findings of but also, as raised in our supplementary skeleton argument, it is also inconsistent with the appellant's own evidence. That's Mr. Lemaire's own evidence, which the trial judge regarded as important, that there was nothing wrong, his words, nothing wrong, Mr. Lemaire's words, in the claimant raising his questions as to the correct accounting treatment under the relevant accounting principles with PwC. Rather than my point about submissions in writing and the emphasis of a case shift depending on as I say, the appellant based that central premise on the first sentence of the first paragraph 48.
Somewhere along the line, I think you should come back and actually take us to the evidence. I think to some extent arguments about whether or not a challenge can be made against findings of fact. Trial judge put in greater depth in the sense that both of your skeletons work on assertions. There's no contextual evidence from the transcript, from the witness statement, to actually give us some color into the actual factual all of the things that you've talked about just now might be useful just to us the parts of the as reasonableness at this stage. The fact that the judge has made a finding of fact doesn't mean you have to accept it, drawing a distinction between primary fact and secondary fact, and secondary fact is most of what you are talking about, which we had in the round.
First is that, as I propose to show you in paragraphs 42 to 48, a number of the relevant transcript references are set out in the passage.
I'd like to see the underlying evidence for his conclusions.
Underlying the fuller transcript references. But can I back to my first observation? Grounds of appeal. There is no ground of appeal challenging the judge's finding of fact. If there was that's why there's no. It's not gone into in detail in the skeleton arguments. It's not a ground of appeal that the judge made either perverse findings of fact or made findings of fact which were inconsistent with. And in terms of the threshold, and no doubt the reason for that, heard and saw the evidence.
That's for primary fact, not secondary.
With respect, I go back to my second point, that there is
Stockhauser yesterday spent a lot of time, and I showed him the parts in his skeleton where he on a number of conclusions by the trial judge, And his main criticism is that the reasoning of the trial judge was unsound. So to that extent, your point that he doesn't challenge the underlying finding of fact is something. But for me at least, in order to assess strength or otherwise of Mr. Hockhau's argument, I need to know a little bit about what actually happened and when, and give us some factual context. Because at the end of the day, we are being asked to say what would a reasonable lawyer have done, and we need to have the whole factual picture in order to come to that conclusion.
Ronnie, you've asked the question, so of course I will answer. I will do so. Can I start by going through paragraphs 42 to 48 of the judgment? Because in many respects, if one goes through that carefully, in my large extent, the answer to the question that Your Honour is raising. So can I start? External bundle pagination, page 30. The judge at paragraph 42, for determining the issue of the inflation, bear in mind what's been made, and he says the defendant relies on the following factual allegations in support. As A, sending revised calculations and an inflated revenue figure to PwC. Following completion of the preliminary audit by PwC, failing to draw to the attention of Mr. Lemaire, Elseco account team, an email from PwC which included causing the 2013 accounts to be prepared in a manner which accelerated the accounting of 2014 revenues, resulting in a non-compliant inflation of 2013. Hence, paragraph 7 of the defence D, prepared accounts which did not show of the profit and loss of the defendant. Paragraph 43, he makes some observations about A, B, C and D. Paragraphs 44 through to 48 for these sets. 44. In my opinion, claimant's conduct has never gone beyond being transparent suggestions, and I'll come back to that suggestions in due course because you'll see. Defendant, accountants, auditors and management to recognise revenues which have not.
Difference between accountants and auditors?
Own accountants, auditors, and there.
Just that he used management as well, so I would have thought that the internal accounts team would have been part of management. But never mind. Go on.
No. Sorry. No. Internal accountants, management of which the.
Exactly.
As with Mr. Lemaire. So what he's identifying there is that the communications are not just with one party, the defendant, suggestions to the defendant, and I think there he means must mean Mr. Lemaire.
By the way, what was Lemaire's position, please?
And at that point, the 100% share. Defendant, the accountants, i.e. the external, auditors, PwC, and management. And you'll see. And you'll see. Then in paragraph 45 sets out the. If I go on to that evidence, can I just address this now, just because avoid me having to come back to it. On the substitution point, My friend referred you to two paragraphs, paragraph 44 and paragraph 97 or 98. Can I just make this clear? Your question was in the context of our... Paragraph 40. So my submission, that relevant in my which are and he then says, I reached my conclusion based on the following evidence. And just before we go on, important to remember, principal complaint made, the principal conduct relied upon in this case, both contemporaneously and at trial, was this fraudulent inflation of the accounts. That's a relevant factor when considering Article 59A. Paragraph 45A. First document is the email sent on the 27th of January 2014 by the claimant to his accounts officer, Roland Kaipanu, copying in Mr. Lemaire's wife, who was going to take over as CFO, and Anne-Marie Chong, and she was the appellant's compliance officer. Stating that the recognition of revenues for launches postponed from 2013 to 2014 relating to the audit were items under review. 7th of January 2014, February meeting. And you asked about the underlying transcript. I will take you in due course to Mr. Lemaire's cross-examination, where this date, he believed that did not raise it with him 7th of February. And on the basis of that conclusion. Pausing there, 27th of January, internal email, which Mr. Lemaire is copied, at which this issue of the treatment of the revenue of these revenues is raised. It's under review. B. My learned friend referred to a spreadsheet yesterday. The judge had this in mind. 45 spreadsheet of revenues attached to the email dated the 28th of January 14, in which the claimant provided the data requested, that's the data requested by highlighted what he believed to be the effect on revenues if, and I'd ask you to underline, if revenues from postponed launches remained, in his words, unrecognised, without actually adding those postponed revenues to the equation or final revenue figures.
Was this email sent? I thought you said that PwC had requested the data. Did I hear you wrongly?
That's correct. So that's why the email is being sent. So PwC requested the data, hiding the data requested.
Second thing is, what's the story about this? I mean, this is the kind of background facts we need to know.
As we'll come on to, and you'll see it's developed, at a lunch at which the issue was discussed with the Auditors asked Mr. Lemaire for revenues information. Provided that spreadsheet. And as we'll come on to see, you'll see that these are the emails. I say, if we look at them all in total, on the 29th of January 2014, so this is the next payment, provided PwC, copying the defendant's accountants.
Internal or external? Internal or external?
External. Sorry.
I think.
Sorry, no, I'm being corrected. I'm being corrected.
No, you're right. I understand. Yes.
No, I'm being. Internal, not external. A recalculated figure in respect of unrecognised revenue relating to commissions from planned launches. Sets out what the email actually says. Preeti, Anjana, so these are. I refer to my email of yesterday, so that's the email you've got in B, which have not yet been shown in any of our accounts, and for which you are doing a research on IFRS rules. So just pause and I'll ask you to underline, and for which you are doing a research. That provides you with the context in which the internal accounts team. I have recalculated the amounts. As discussed, the unrecorded revenues come mostly from commission committed in signed contracts for which the launch is to occur after December 31st, 2013. What does the judge say? This demonstrated to me that until the date of this email, revenues hadn't found their way into the defendant's accounts. So he's there addressing this argument of. Then D, on the 2nd of February 2013,
Right.
there in that sentence, this demonstrated to me that until the date of this email, revenues hadn't found their way into the account. He's there addressing the allegations in paragraph 42. Actually dated the accounts. I say, as we go through each of these, you'll see the whole picture come together. And this is the underlying contemporaneous. D, on the 2nd of February 2013, PwC sent the claimant, Mr. Lemaire, his wife, Anne-Marie Chong and Roland Caipuno, an email date entitled Status Elseco as per first phase of the audit. This email reads, so again, this is 9 to 10 days. Your information, kindly update the list if I have missed something. Thank you for all your help and support. Hopefully we'll see you soon for the second phase. Bottom. The attachment to the email contained a list of topics intended to be the subject of further discussions during the second phase of the audit. One of the topics for further discussion included the proportional. The relevant section of the attachment reads further discussions, premium tax adjustment, proportional revenue recognition. Billion of revenue 10 days before the 11th of February meeting. 5.2 million of revenue which has not been recognised because it has not hit 95% mark yet. However, work is completed and no additional or very less work is needed before the launch. This is due to delays in a considerable number in the year.
And who is the author of that?
PwC.
Doesn't look like it, does it? The attachment,
Yeah.
I don't know who did the attachment. You're telling me as a matter of fact it was PwC?
Can I come back to you as to the... It's an attachment to the PwC.
But I don't know whether it attaches a memo from somebody else as a primary document.
My instructions are that it was PwC.
Just thought that it was slightly informal for an accounting firm. But
Then this, what does the judge make of it? This evidence that the matter does not, this evidence is that the matter does not go beyond discussion, which Mr. Lemaire confirms during his testimony before the court. So Mr. Lemaire is cross-examined about these documents and what they show. That is a topic for further discussion, is it not? Yes. That is a further discussion to recognise it, or not recognise it, as the case may be. Recognising it or not recognising it. Wanted to have it that way, do you accept that he, even in your case, and this is not accepted by us, he put it up there for further discussion. He had put it up there as an open item. Mr. Lemire, correct. And then
what I mean by having more flesh on the bone. You can read this memo. Obviously, it means something to the people who are. For us, first of all, we don't know what launches you're talking about. We don't know what kind of income you're talking about. Why do you have commission income? I thought they were insurance. Well, sorry, they were insurance.
they're not brokers exactly, but they're a type of broker.
Yeah. So you have to explain this to us. And are we talking about cash in the bank as opposed to in the accounts? Or are you talking about accruals in the sense that invoices have gone out or not gone out? All of these give you some understanding of what the actual financial picture was.
Actually said and how it's addressed. As a headline answer to your question, would have got the money in.
Work for what? What is it to do with the launch? You see, this is what I'm doing.
Well, we're talking space shuttles. That was their business.
The mission had already been agreed. Insurance hadn't been accepted until the
I thought the launch was of an internal campaign by the company. That's why I thought the launch was a launch by the company of some campaign. Well, you see, this is what I need to know.
I say, can we go through these paragraphs and
Yes.
then I'm happy to come back to in more detail. Ultimately, my learned friend inquiries were made in good faith. Quite happy at that stage to then answer any questions as best I can. Subby, and this is a critical paragraph. During his cross-examination, confirmed in relation to the claimant's email to PwC that there was no instruction to PwC recorded revenues in 2000. There's concession number one. No instruction to PwC to unrecorded revenues in 2000. Second key concession, what Mr. Lemaire conceded, no more than an invitation to PwC to opine on whether or not, and I say recognising deferred revenues would be conceded that all the claimant was doing, had done, was give their opinion whether or not the relevant revenues from the delayed launches, deferred revenues from the relevant launches, would be compliant with the relevant accounting principles. Proposal, request for advice as to the correct accounting treatment of these particular revenues. The judge says is that further evidence is that the claimant's actions did not result in any actual inflation or harm to the defendant's accountants. Then these words, and these are the judge's words, findings, more importantly, the mayor conceded that there was nothing wrong with PwC being asked to research how the relevant accounting principles, IFRS, would apply to revenues due from 2014. So, learned friend's submission yesterday, the premise of my learned friend's submission yesterday was that the communications with PwC were done in bad faith. The mayor's evidence, when cross-examined, was that there was nothing wrong with it. And the judge doesn't just make that finding, he sets out. They are a big auditor. I think we can agree on that. But they are being instructed to research the question of whether or not or how IFRS would apply to these unrecognised revenues. So again, it's whether or not or how. So he's asking, the CFO is asking the auditors, the relevant people, item, the deferred revenues, be treated under the relevant accounting rules.
Actually, haven't request, have we, by these all at 45C?
But A, B, and C is what we've got here.
Okay, so the only is this where you derive this question about a request for research?
Yes.
Line 2 to 3.
Well, certainly this is where it's clear in the judgment, in the C, and for which you are doing a research on IFRS. That's 45C, set out in the email, the end of the second line. That's consistent with that email. The defendant's internal team are... Can I just carry on with cross-examination though? Mr. Lemaire, correct. Mr. Dar, what is wrong with that? Mr. Lemaire, right. So Mr. Lees as CFO, so this is relevant because my learned friend placed much emphasis yesterday on the fact that was the CFO. Well, these concessions are made with Mr. Dar squarely raising the fact that the claimant is the CFO. Right, so Mr. Lees as CFO, if he is not sure about something, he is entitled to defer to the good sense of the auditors, is he not? Mr. Lemaire, I think if he's not sure of something, he should speak to management. Yes. Well, is it your complaint that he did not speak to you and tell you that he was going to invite PwC to do some research? Answer, no. Mayor in cross-examination says he's not complaining. He can ask PwC to do some research, But I think clearly it was an important point, and I think it's important to mention that to the management, I think. So that is his crime. He did not mention that he wanted PwC to do some research on IFRS. That is his crime, is it? The fact that he is asking a question is not a crime. I think it's a good thing that he does it. So Mr. Lemaire's evidence was he thought it was a good thing that the claimant was asking PwC what was the correct accounting treatment of these relevant revenues, deferred revenues. So I'm very happy for anyone in my company to ask questions, especially during audits. So again, it's this point about especially during audits, and we'll come on to the SEA.
But what was the financial year of the company?
Ending 31st December 2030.
At this point, talking about the accounts for
Year end.
quite late, isn't it? This happened in.
When you say this, the discussions take place at the end of January 2014. So within a month of the...
Right. Right. Okay.
So Mr. Dahl says, so what is the crime in this email? Now, when you've got questions which are directed and which are the wrong title for purpose, that's the problem. And the judge clearly doesn't question. It says, but what are you saying? He is not allowed to deal with PwC directly and ask them for research, test anything? His answer, no, he's allowed to do. No, I think he's obviously allowed to speak to PwC and ask for research. So there's no problem with that at all. Automatic answer. This isn't just about a one-off concession. The judge is looking at the cross-examination in the round. His Excellency Justice Al-Madani says, so he is allowed to do anything, and then it is for you to approve it or not at a later stage. Is that right? Correct. Correct. As I say, this is raised squarely in response to my learned friend's point. I say that that passage, critical passage, the first stage of Article 15. Bearing in mind that this is the self-same conduct that the appellant in this its statutory reasons, in its defence, relevant to stage 1, but also relevant to stage 2. When you come to consider what the reasonable employer would have done, got Mr. Lemaire saying, wrong. This isn't about serious misconduct. F. Furthermore, the fact that the claimant's actions did not constitute serious misconduct and were, and this is a finding of fact, done with the knowledge of the company's management. There you've got in F a finding. Were done with the knowledge of the company's management. Goes back to transparency. That is strongly supported by the evidence of Mr. Roland Caipuno. You recall. Then G. The expert appointed by the claimant concluded that the email exchanges between the claimant and PwC were, and the judge it's underlined here, standard in the context of an audit. And in my submission, when you read that in the context of the opening to paragraph 45, followed based on the following evidence, it is clear that first sentence, accepting that the communications between the claimant and PwC were standard in the context. H. The claimant's willingness to attend the meeting to discuss issues surrounding the company's accounts and deferred revenues with the auditors and the management, including Mr. Lemaire, further demonstrates that the claimant or the final steps of the paragraph 46. I am satisfied that the claimant's actions amount to no more than an inquiry. Just pausing there, an inquiry. And we know from the paragraph 45E that's consistent with Mr. Lemaire's inquiry as to the correct accounting treatment. Auditors, accountants and management. Then importantly this, which serious misconduct, it's not. Not result in any actual inflation and was in any event finding done in a transparent way in accordance with the company's procedures. This paragraph, to which I will come back to, is also obvious from Mr. Lemaire's own evidence that he haphazardly concluded that the claimant was acting fraudulently based primarily on an justified and arbitrary presumption of guilt. Again, finding a fact based on Judge Madani's careful evaluation of the relevant contemporaneous documents There is this passage in the cross-examination that he alludes to, he refers, bears reading out. The question that Mr. Darrett posed was, well, alleged fraud. Say you believed it fraud. What was the evidence? What was the basis of that? The evidential basis to that? Point me to some evidence. And what's the answer? I think it's the addition of many evidence.
When we see the evidence, judge's conclusion that Mr. Lemaire believed the claimant was acting fraudulently. I mean, it's not in the passage, is it?
Set out before, but can I just give you reference?
Well, I'm sorry, could my learned friend point out where fraud is alleged in 6.6 or 6.7?
Article 60, it took the 2 months by this Article 60 letter giving the reason for dismissal. I would take you to it. I will take you to it. It's in this bundle.
A20.
I'd ask you to keep a hand in here, though, please. But also, can I just say this, is that this cross-examination, this is the cross-examination where Mr. being asked questions about, well, why did you think it was fraudulent? Evidence. So it's even in the cross-examination. The point I was going to take you to was page 308, where they give the reason. Tab 20, volume A. Tab 20, volume A. Top of page 308. Second sentence of that paragraph. The reason for the termination was attempting dishonestly to defraud Elseco for your personal gain in the amount of £5.2 million, demonstrating a willingness to act against the interests of Elseco.
Yes.
What's the evidential basis for Mr. Lemaire's conclusion, which I'll also take you to the passage. Back to the cross-examination. Mr. Dar says, which in particular? I mean, first of all, I think, if I may, a bit of context. Knowing someone for 8 years and knowing them very well, far, far better than you know your client, I take it, okay? So I knew when something happened. When you deal with someone and you are 2.5 meters from him, you know very, very well what's his intention. So you presumed his intention, did you, on an arbitrary basis? Yes, that is interesting. Yes. Volunteers, that's the beauty of a company. They know you, you know them. Just by looking at it, you know. And I think the same thing with family. When you see your mum all right, even if you are 10 meters, she will tell you if you're sick or not, okay? She doesn't have to be there and ask you the question. She knows. In the context of him being asked to identify the evidence, led him to conclude that
it would have been good if the judge had included the question just before
I'll take you back to it, because interestingly, I'm happy to take you to the underlying cross-examination. Interestingly, the judge follows up to that answer and saying, so, as I say, it's to my first advocates to make submissions. Judge's decision formed by not just the contempt, evidence that he has formed. So, in my submission, that takes us to paragraph 48.
Verse 48.
Verse 48. My submission were only taken to this paragraph yesterday, but I hope I've demonstrated that when you because you have the charge. That last sentence, and the transparency in the claimant's approach suggests that he acted in good faith. Transparency, permissible. Tenant's own concession that they and critically, no appeal from those underlying findings of fact. So, just take when you asked my learned friend yesterday, the tenant was entitled to dismiss under our very strong answer to you was based on paragraph 48 and the claimant, the CEO, had been in bad faith in breach of premise, fundamentally undermined and inconsistent with the trial judge's express findings of fact.
Done with that section?
I'm moving on to the third point, but it's a linked point. So,
Common property, the company property point?
going to come on to that, but the obviously a related point, and related for this reason, and this is my third observation. Third observation.
Well, before you get to the third observation, let me ask you, because you said that you were going to take me through, and I still haven't heard what I want to hear. I want to know what the underlying dispute was between Mr. Lee's and company or Mr. Lemaire in the sense of what the factual situation was and what was the differences in opinion, so that we can, without that I can't decide whether or not the position taken by either party was reasonable or unreasonable. So far, as what I understand from you, to save you repeating it, is that the company had arranged insurance for a satellite company which was going to do a launch. And reading between the lines, it seems that the insurance company or companies had agreed the rate of insurance commissions paid. The launch was not going to take place in before 31st of December 2013, but was postponed to sometime in 2014 or perhaps even later. But the rates of commission have been agreed. So what I want to know is, when were the commissions payable? Had invoices been sent out? Had cash actually been received?
I just take instruction.
Commission will be payable out of the premium on payment. That's basically, won't it?
But had the premiums been billed out, you see?
One would expect in the ordinary way that the commission would be payable out of the premium round about the time of inception of insurance, or if it was payable by instalments over the period of insurance. That was one, not in this case.
I think that's why there may have been some doubt as to the correcting.
Put it this way, there was no cash in the bank.
Not on a cash basis, my Lord, I'm instructed.
not quite as straightforward. Very conscious. I don't want to paraphrase incorrectly.
Give us the reference and we might read it over the lunch break. Don't understand, we'll come back to you. The reason why I ask you is to see whether or not the position advanced by Mr. Lee's in relation to the accounting treatment of this 5.2 million could, in layman's terms, be considered to be reasonable. Le Maire, let's say, we assume that he doesn't have any specialist accounting qualifications, and he's saying, you can't go and ask for this thing. This is clearly unreasonable.
But we know that wasn't his effort.
I'm so sorry?
We know that wasn't. I'm happy to
I
go
don't
back
know.
to
I
it.
mean, isn't that what he's saying in the letter? You are trying to get something you clearly knew you were not entitled to.
He's cross-examined about it. Evidence is as set out at paragraph 45E.
Well, my lord, it's not, because my learned friend said he was going to go to the evidence, and there's a critical passage in the cross-examination that is not there at page 801.
Come back to us on that later. But
We'll have a look at it now, so that you can do
see,
it.
this cross-examination is only about the stage at which he was writing to PwC. Shown us that, as far as we can see, the language was, he says, well, consider this as a way of treating 5.2 million, whether it's also a revenue recognition, and whether you recognize it in this financial year or the next. And that, frankly, is determined according to, the bean counters rather than by the people who actually manage the business. So he's asking. So on that face, that is what Mr. Le Maire seems to be eating. Yes, you can always ask, but somewhere along the line, he's formed the view that it was a totally unreasonable request, and he was somehow trying to pressure PwC into seeing, into adopting his point of view, right?
But Your Honour, that's what 60 letter says. Being done here, there, and what's relevant is what is the evidence that he gave in cross-examination? What did the judge? Because that's what the judge has to look at. Yes, he looks at because in paragraph 42, the judge isn't evaluating it out of context.
No, I mean, I accept.
He's
Okay.
evaluating it. He's evaluating it again in the context of. That's all the claimant can do is cross-examine the allegations that he was demonstrated. When you go through, you see I identified the 4 concessions that Mr. Le Maire made. Now, and in my submission, that's the starting and the end of it. Those are unappealed concessions, findings of fact. Don't form part of the grounds of appeal.
But a pretty clear indication, don't we? From quote WC. Unrecorded revenues come mostly from commissions committed in signed contracts which the launch is to occur. So you've got the contracts in existence, but presumably the insurance hasn't incepted at that point, and therefore the money hasn't yet been received. That's basically, and as you say, you're looking there for the question of potentially accruals.
I mean,
Yes.
Second sentence,
Yeah.
where the judge sets out the circumstances. The majority of work has been completed. Very little or no additional work for its launch, which has led to the non-recognition of revenues which would otherwise have been recognised, were it not for the delays in a considerable number of launches in a year.
yes, but you see, if the launches actually are cancelled, not be any premium payable. I don't know, you see, but
in my submission, that's
why I'm saying,
preeminently a matter.
look, listen to me a moment, please. This is a limited scope of inquiry. I understand where you're coming from. I just need to have a little bit more factual education about what the point that was in issue and what Mr. Lees was trying to advance, and whether or not that sort of thing that he could be believed would fly. And you've given us this evidence, but I'd like to see that evidence in the context of what actually happened. It helps when we're writing the judgment.
Both sides put forward their own expert evidence. Can I just draw your attention to a submission in relation to the point that you just raised? It's paragraph 35 and 36 of the judgment. This is the judge reciting the submissions. Paragraph 35. Thirdly, the claimant relies on his expert's report, which he argues confirms there was nothing unusual or out of the ordinary about the claimant's communication with PwC as part of the audit process, and that such communications are to be expected between the auditors and the CFO of a company. Lastly, the claimant contends that there is clearly a divergence of opinion between the claimant's expert and the defendant's expert regarding whether the recognition of deferred revenue for launches should be postponed, or whether those due to take place in 2014 ought to be included in the 2013 accounts. The fact that that approach to revenue recognition is a matter of debate between the experts supports in the claimant's view the legitimacy of the claimant's conduct in seeking guidance from PwC on revenue recognition. The context in which the judge is making his findings. And in my submission, as I say, I'm not an expert. The trial judge had expert evidence before, and the trial judge is there recording the claimant's submission. That each expert said something different as to what the correct treatment. The claimant is there, I think, with respect, is making the point that Your Honour was making. The claimant was making the submission. Well, if the experts can't agree as to what the correct treatment is, the trial judge found as a fact that it was the mayor conceded. Lunchtime, mind you with the references.
Make it helpful for you. I don't even see that those concessions and those findings were necessary for the Lees was at the time the CFO. The CFO has overall responsibility for the presentation of accounts.
Yep.
By January, I assume that accounts would have been closed, the trial balance would have been done, the draft P&L and balance sheet would have been assembled, and there might have been then informal discussions, maybe even formal discussions with the auditors. This is the way we want to present. But what I'm understanding is that in these draft accounts that were being discussed with the accountants, the figure of 5.2 did not show as revenue recognized, despite Mr. Lees being the CFO. Presumably he had a disagreement with his internal accountants.
In those paragraphs in 45A to D, what 85A to D is showing is that in the accounts the revenues were not recognised. Auditors here's the accounts, but you should know that there is these unrecognised sums, and what do you say is the correct treatment? That's the context of these discussions.
Yes. But of course, in this case, we have the factor that he had a personal interest in this.
Yeah.
There was that evidence which we saw yesterday that at this critical meeting, was it on the 11th? The mayor wanted to have a word with PwC privately, and then, the history of this thing came out. So that's a little bit blurred in terms of what is slide here, so what is set out here. which gives the picture of complete transparency, and the evidence that was in that meeting of the 11th of February, which seems to suggest that there were certain things that were communicated between PwC and Mr. Lee, not disclosed to Mr. Lair until that particular meeting. And then when Mr. Lees was called back to the meeting, he then insisted that his interpretation was right. He became an advocate using reference by the IFRS. He could have done that in good faith, but we have to take into account the fact that he had a personal interest. But of course, the personal interest was known to Mr. Lemaire. So at the end of the day, it doesn't matter what the two of them argue about. PwC are going to make the decision because they have to sign off on the accounts.
There are 2 points to this, if I may. One is they both had a personal interest. So in terms of these discussions, yes, Mr. Lemaire had a personal interest.
What was Mr. Lemaire's interest in having it recognized in 2013?
Not being recognised. Because of course, it all that would if it wasn't recognised in 2013, Lee's under the agreement. You might see why Mr. Lemaire. To me, and also a point he made yesterday, because he repeatedly emphasised the fact that the recognition of these revenues, he said, previous methodology. The point is, in that respect, this is where the personal interest comes in. Irrespective of that was the Cooke. Mr. Lees is the CFO. He is the DFSA, so the financial service authorised person. It is make sure that these accounts are prepared in accordance with the relevant accounting. Their private agreement says, because these are being prepared, these are the formal accounts being approved by the auditors, it's his responsibility as CFO to make sure that these revenues are correctly treated under the relevant rules. That means that that is inconsistent with audit with PwC.
You're not telling me anything I don't know at the moment.
I'm responding to my learned friend's submission. My friend was, again, it's central to his submission that the claimant was seeking different to the methodology. All I'm saying is responding to that submission that was he was acting in would result in it being prepared in a different way. The obligation was to make according to the relevant accounting rules. Perfectly permissible. Make the to ask the question. That is why Mr. Lemaire conceded it.
I know that part of it. I think we understand sufficiently. Okay.
Can I?
I'm going to go on now to your next observation.
Can I move to the third observation? Sorry, can I just pause there? And make the point that the evidence. Now that was a dispute. Was a dispute about that between the parties. But just to put the claimant's position.
Well, the judge refers to that, paragraph 38.
And, my lords, he does find that it goes against the previous year's account.
Yeah, indeed, he records that there was an argument about it.
And one has to be careful about what the requests are in terms of what was done in the previous years. third observation, but it's a connected observation. You'll recall in those relevant paragraphs, I took you to paragraph 47. Sorry, yes, 47. It is also obvious from Mr. Lemaire's own evidence that he haphazardly concluded fraudulently based primarily on an unjustified and arbitrary presumption of guilt. Finding of fact. Then got the finding at paragraph 65D. Got the finding that Mr. Lemaire's conduct on the 11th of February 2014 was unreasonable. Do you see that 4 lines down? I'm inclined to find that the employer's conduct was unreasonable. Might have genuinely led the claimant to be concerned about the destruction of hundreds of emails that would have vindicated. So you've got. So that's not. So that's separate unreasonableness. That's not. Got the finding that that was unreasonable, and you've also got the finding at paragraph 95. Judge's finding that the claimant, in his capacity as Chief Financial Officer, board member and co-founder of the company with a special interest in the company's final accounting year, was entitled to attend the meeting between Mr. Lemaire and PwC. So this is the company's external auditors. External auditors, at least to the end of the accounts discussion, which was a controversial issue between them. And we have Mr. Lees was excluded from that meeting.
At part.
Oh. The question that it was a discussion about the accounts that he was excluded. Meeting that the judge finds he was present throughout the accounts part of that meeting.
That in terms?
I'll read again, paragraph 95. I do take the find the claimant in his capacity as Chief Financial Officer, so responsible for the accounts, treated in accordance with the relevant rules, board member and co-founder of the company. So in each of those, judges saying, in each of those capacities, he will end the meeting between Mr. at least to the end of the accounts discussion. The corollary of that is that Mr. Lemaire must have acted unreasonably in having a private discussion with the external auditors about the accounts. As I say, in my submission, you read paragraph 47, haphazard, arbitrary, unjustifiable, reach the conclusion of fraud. 65D, the unreasonable handling of the events of the 11th of February. 95.
Did you say 65D?
Paragraph 65D.
Oh.
How Mr. Lemaire acted on the 11th of February. My submission, you've got to read 65D, paragraph 95 that I just referred you to.
But this is where Hockhauser complains that that factual finding was incorrect in the light of the undisputed evidence, isn't it? He was called back to the meeting, and he was.
That's a point. The defendant had two payments. The defendant's account is Mr. Lemaire's private part of the meeting with PwC. Discuss. What you have at the top of...
There's no finding of fact on that.
In my submission, implicit in that first sentence in D is an acceptance. Following the meeting of the 11th of February 14, Mr. Lemaire had not, I'd underline the words, at any stage, sought to afford the claimant with an opportunity to comment. That has to be read in the context of the claimant. There would be no reason for that finding. The claimant had been given that opportunity. First sentence is wholly inconsistent. Taking a step back, in my submission, you've got those three critical findings in 65D, 47 and 95, and they all relate to the employer's conduct.
Right, just give me the paragraphs again, please.
So it's paragraph 47.
47?
47.
Yeah.
So that's haphazard,
So
arbitrary.
just give me the numbers.
47, 65D, and 95. In my submission, those findings, as I say, which were not referred to by my learned friend at all yesterday.
Paragraph 65 is referred to at length.
Bench heard the submissions yesterday.
4 paragraphs, I've only got 3 at the moment.
No, it's
Okay,
47, 65D, and 95.
have that. Thank you.
In his examination of the seriousness, claimant's conduct, nowhere was it put into the balance or consideration given to the employer's conduct. My submission, given the inextricable link, claimant's conduct, really when it comes to in my submission, the assessment under both Stage 1 and Stage 2 of Article 59A, those findings about the employer's conduct are critical to that question. And in my submission, the flaw in the appellant's approach is to extract one fact, either the taking of the laptop or the exchange between as he's leaving the office, culmination of those events, look at those facts in isolation without reference to the employer's conduct which were inextricably linked to and led to both of those acts. My submission, they're relevant in these respects because in applying Article 59A, either a reasonable employer would not have acted, reasonable employer, the construct, would not have acted arbitrarily and unreasonably, and so would not have made the unjustified allegations and unreasonably excluded the claimant from the 11th of February meeting, and so caused the claimant to be concerned about the destruction of the evidence which would vindicate his conduct face of those unjustified allegations. Therefore, the whole situation on the 11th of February arisen. That's one way of applying Article 59. The other way is to say that the reasonable employer, so the situation, so that first situation is under Article 59A, that in the hypothetical reasonable employers, Or the alternative way is to say that the reasonable employer, knowing that he had irrationally and arbitrarily made unjustified allegations and acted unreasonably so as to cause the employee to genuinely and reasonably fear it may destroy the information which would vindicate the employee, would not have dismissed. The judge was correct to say in paragraph 64 as mentioned above, the claimant's retention of company property and necessarily justify instant termination by his employer. However, after a trying to accept the claimant's submission that the conduct was not so serious to warrant his immediate termination. Oh, the careful have included in paragraphs 47, 65D, and 95. He says the reason accepts that in paragraph 63 he accepts the judge correctly directed himself as to the definitely required circumstances and factors surrounding the action at the time of the term, in order to answer the question of what a reasonable employer would do. Judge's recognition that you don't, as the appellants seek to do, dive off and extract particular elements of conduct and look at them in isolation and out of context. That a critical feature in this case was what had led to that conduct. Arbitrary and unjustified allegations of fraud. 11th of February, meeting, taking of the laptop, and the exchange after the meeting on the 11th. To apply Article 59, as I say, that either the situation would never have arisen, the reasonable employer would not have been in that position because he would not have acted unreasonably unjustified, or, alternatively, the reasonable employer, if it had arisen, the reasonable employer that it had arisen because and in my submission, all circumstances and factors surrounding the employee's conduct would include the findings in paragraph 43. Also the finding in paragraph, and those paragraphs would also have informed paragraph 65D, and it's also relevant in my submission to the response. Also, the points I've just been making, so this very heavily on those second and third. The result would have been the same. Bearing in mind that the Article 59A question, as we'll come on to see, is not the higher test. higher threshold. Ronnie, you asked me about the cross-examination, cross-examination. Can I take? Transcripts are in bundle B. Do you have two bundles?
They're bundled B1 and B2, and B2 is the cross-examination.
Please, could we go to bundle 2, please? Page. So you'll see Mr. Lemaire's cross-examination starts at page 7. First passage I wanted to take you to was 769, please. Pages that we don't have to go through. Examine. Even then, it won't get it. Observing. I first of all then ask
We're
you
not
to
concerned with the issues of credibility because that doesn't seem to arise in the appeal. But I don't think we are concerned with issues of credibility. That's why, you keep on saying that we didn't observe the witness. I mean, in fact, I think, take it that we understand the principles of how trial judgments are reviewed in the Court of Appeal. I told you, there is a difference between findings of primary fact and findings of secondary fact. Court of Appeal is fully equipped to look at issues of secondary fact.
primary or secondary findings.
With respect, my Lord, that is simply not correct. And if you look at the finding about the return to the meeting, and that is contained both in the notice of appeal and in the SCO's argument.
We'll hear you in due course on that. Thank you. Yes, carry on. Sorry, what document are you asking us to look at?
Page 712, by the first hole punch. So he is bringing to the attention of both of yourselves items relating to the accounts that are currently under review, which normal email in the process. It's addressed to the entire accounting team, and he's talking about this is correct. over at 713, the bottom of that page. Prior to this is the end of January, prior to the 2 weeks prior to the 11th of February. Bottom of that page, he is bringing that as a topic of discussion to your attention, is he not? What he's bringing to attention is in between the two whole punches there, revenues relating to the postponed launches. There is confirming, yes, he did that. He did bring it to my attention. Then turn to
Hang on a minute, this is what you referred to. 714, there's some reference to recognition of revenues on a cash basis instead of accrual. And I asked the question and nobody answered it. I think whether or not there was cash in the bank from these commissions.
I'm told that there was some cash in the bank for and 15 and 16.
No, but
as at the 31st of December. Launches that took place. And 16. Then ask you to
for
turn
14 and 15.
14, 15 and 16. But this is the position as this is there was and 15 is as at the 31st of October 2000. 31st of December, sorry.
And it had been invoiced.
The payments will be made.
Contract being between the Elseco and somebody else?
Elseco.
Sorry.
Bear in mind that Elseco money, the insured pays the money to Elseco. Take their commission. That payment, insured, sorry, the broker. So bear in mind that it's a multi-party arrangement. Insured pays the money to Elseco. Broker to sort of broker. Yeah, sorry. I put the broker in one. Elseco.
The opposite way round from what I was expressing before.
Well, it's 5% that is paid, and it's refundable if the launch doesn't.
That was my next question. Thank you.
I'm told that's wrong, but as I say, this is all
Dispute. Yeah.
factual. Well, it was part of the factual disputes that.
So it's not critical that we get to the end of it. It's just to understand whether or not, if you like, I mean, as I tried to put it earlier, I mean, whether or not Mr. Lee's had an arguable case that it should be recognized. And the ultimate result is that with the accounts that were issued for 31st December 2013, the 5.2 million was then not recognized. Is that the position?
By that point, the claimant had been excluded, but
The 5.2 million was then not recognized for the accounts of 2013, and so, Mr. Hockhauser, you obviously you are including a claim for the commission, which you say is due to you. Is that right? I thought I saw it yesterday when I was looking at the claim.
No, there was a counterclaim that was advanced, Your Honour, in relation to expenses, but the judge found that they were not sufficiently particular. Therefore, he made no award under the counterclaim.
But weren't you claiming that you should have been entitled to? Well, of course, you're claiming for the wrong party. You would have to claim it against Mr. Lemaire, right? Yeah. I mean, I'm just assuming that Mr. Lee is being
Mr.
consistent.
Lemaire wouldn't be claiming against himself.
No, if that's what I said, I misspoke. It's Mr. Lee's consistent with his position would be claiming, but then I've just corrected myself by saying that that claim would have to be made against Mr. Lemaire personally rather than Elseco. Yeah, carry on.
769.
Same bundle.
Yes, same bundle. Examination about the emails with PwC and that were copied to applications. And what Mr. Dar says, so representing Mr. As you see towards the top of the page, here was you suspecting or believing rather that your CFO was being dishonest and fraudulent. Correct? Correct. So that's Mr. Lemaire confirms, as at the end of January, he believed that his CFO was being dishonest and fraudulent. That he was trying to gain dishonestly 5.2 million or 4 million, correct? What's in the amount, but yes, correct. Effectively stealing it from you, stealing it from the company, I think. Yet you have no conversation with him. You do not raise this subject until a meeting 2 weeks later, on the 11th of February. This is correct. So I go...
What's the reference event for this 2 weeks later?
So if you recall in paragraph 45, February. Certainly got the 27th. Those other emails. The point is he is here confirming that at the point of those communications, he believed at that point, at the end of January, that his CFO was honestly and fraudulently seeking to inflate the accounts for his own personal gain, and he was confirming in this passage of cross-examination that with that knowledge, he did not raise those allegations with the claimant until, for 2 weeks, I ask you again, Article 59, I don't ask you, but I pose the, I say that in considering waited 2 weeks.
But if I read the next page, that point is exactly put to him.
Expecting this answer, Mr. Dar. Well, I will comment on this in due course. Trying to somehow entrap Mr. Lees by not raising this issue. What I'm agreeing with is the fact that I wanted to give him a chance. I also see the truth in things. I'm interested in the truth today. See, well, can I finish? You see, if you are at the very least curious about what on earth is going on here, can I suggest to you that you would have... Why have you done this? What are you suggesting, Mr. Dar? No, don't suggest that to me. You didn't run the business, I do. So I understand your running of the business. He is doing it his way, the judge is saying. Yes, Mr. Dar, yes, you are doing it your way. You are the CEO of a business that has a substantial turnover, and you suspect somebody of fraudulent activities, correct? Correct. You do not hold an investigative hearing into this matter, do you? Sorry. You do not hold an investigative hearing into this matter, do you? Not invite him to an investigation meeting to ask him questions, do you? No, I don't. No, you do not present him with detailed evidence of emails for him to digest and cogitate and respond to, do you? No, I don't. Notwithstanding the fact you have a dedicated HR function in your business, and so on. And
well,
so
can we go to the end? If you're going to read that, can we go to the end of that?
Rather my point, Your Honour. I then try and put that in context, read the following bit. And
where is he asking you to read?
Just to the end of the page where he...
Which page, please, Mr. Hockhausen? 77?
7. And the fact you have a dedicated HR function in your business. Staff handbook that sets out the way in which people should operate. All this money, dedicated roles, staff handbook, facts and policies, yet in which of this that is irrelevant. I thought that was the best way to handle that matter was the way I've done it. Well, can I suggest to you that taking the approach that you did meant not fully appraising the facts in this case. You did not. I gave him 10 days. So just put that in context, I gave him 10 days. That's in the context of Mr. Lemire saying, January, that type, he didn't say anything until the 11th of February. So when he says he gave him 10 days, it's not that he put the allegations to days to respond. He sat quiet. He didn't raise these issues with these. And you've got the judge's where he expressly refers to the lack of a proper investigation, which no doubt ties into that exchange of the correspondence.
I wasn't actually quite clear what he meant by in the absence of a proper investigation in that context of...
But I hope this puts that finding in context. what the cross-examination is being put to at the end of January, that fraudulently, dishonestly seeking to inflate the accounts. At that point, you don't raise with him, show him the emails that you sent. What you do is, at a meeting on the 11th of February, without notice, parties.
Third parties are the critical people, aren't they?
Well, they're the critical people as to what is the correct.
Yeah.
They are not.
Well, if hypothetically the PwC had said, no, this is all fine, Mr. Lees is correct, then he would not have had a basis for making the fraud allegation, and he would presumably have kept his mouth shut.
That's precisely the point. When he had those suspicions at the end of January, could have asked at that point. It would have taken a simple email to PwC, pick up the telephone to PwC, correct treatment. Please, what do you say about this? Done in an informed fashion.
It was not, I think, right? This is the
For
time
part-
when he was somewhere
yeah.
else. He was in Luxembourg or something.
For part of it, he was on. Correspondence taking place on email.
Yeah, but there's some things that you might not want to discuss, with PwC on the phone from abroad, but rather leave it for face-to-face, especially with all the parties present. I mean, that's a management style some people adopt.
Got the judge's findings of fact on that. You've got the judge's findings of fact. Bearing in mind, as I say, this is all in circumstances where and were unjustified. Can I then ask you, and 780, you can see all the build-up to that exchange that the judge cites. You see pages 785. Is that cross-examination about the suspicion and
Are quoted in the judgment,
yes,
yeah?
you see 782. Wanted to see the surrounding, how you got, so all of that is part of the build-up to 782. Sessions cited by the judging. Can I also take you to 849, please? Can I just make this point? Out of the cross-examination as well. And this is just a point. Clarify that the claimant did revenue, but was asking PwC to consider. There is a passage in the. May well be that that this is. See that this comes out. I was asking you to turn to page 849. It actually comes in here. Top of page 849. Yes, but with the greatest respect, you suspected him of fraud. Yes. Can I suggest to you that the onus is on you as the lead fiduciary in this company to ask him about it, and you waited until the 11th of February, did you not? Yes. I also suggest that you had a substantial number of questions resolved to your satisfaction at this meeting on the 11th of February by Mr. Lees. By Mr. Lees. by Mr. Lees, when you narrowed down the figures, can I suggest to less than 2 million? It was clear that he was not suggesting the entire 5.2 million be included. Here at the end of the meeting, he didn't suggest it. Thank you. Another part, and if we're going to the underlying facts, it is relevant, the text of all of this, is that earlier in January, in relation to these accounts, Mr. Lemaire had made similar allegations in respect of another aspect of the accounts concerning insurance premium tax. Relevant emails are set out at B1765.
Sorry, which reference?
765. and 766 are related to earlier email exchange in January relating to another aspect.
Denmark, is it? Does it have 700 pages?
But the judge didn't rely on these, did he?
It's part of the evidence. Just to show you the emails, this relevant part of the transcript sets out the emails in relation to IPT.
The page
765. What you'll see is that earlier in January, Mr. Mayor had doubted the tenant's intentions in relation to tax, and you'll see setting out emails from Mr. Lemaire where, after the explanation has been given, it says, all in all, I believe it's a shame to end up 8 years of collaboration on such a note. You told me in various emails that it was not your intention to hide the accounting options from me, and I'm prepared to believe that. Just pausing there for a moment, that's a reference to IPT, is it not? Yes. Then go on to say, I am prepared to recognise that I have overreacted and suspected your integrity on false impression. David says, on your side, I hope you can understand that I'm being suspicious on these topics, so accounting matters. But what you can see in relation to the and what he did, and Mr. satisfied.
What's the date?
It's in January. I don't have the date.
2014.
Yes. And I'm told it's the 21st of January 2014. Context. So what you have is, so you have Mr. Lemaire making allegations of etc. in relation to IPT. He emails when he gets a satisfaction, he gets a response. Days later, he has the suspicions about fraud in relation to the revenues. He doesn't take the same course of email on it for 2 weeks. Just to go on to further point, this is in terms of the that email, the email which he terminates on the 11th of February, how does he start? Page 304 behind tab 19. So this is the termination email. How does the termination email start? We're in bundle A1. (19) paragraph. This is the dismissal email. Elseco's email account when you advised me and the auditors this morning were resigning from Elseco Limited. Was relevant to at the CMC trial, the trial hearing. That explanation, examination, where Mr. Lemaire gone into, well, PwC. On PwC. Can I, so just to conclude on these points, my friend raises the issue of good faith. Demonstrate good faith in the employment authorities he showed you, the emphasis was on the fact that those duties go both ways. Got the judge's finding of fact. (47, 65D). Arbitrarily and unjustifiably fraud those allegations, as the judge said, in an are relevant and no doubt both limbs of the article.
This letter of 11th of February, is that the actual letter of termination?
Yes, that's halfway down that page, you'll see the first hole punch. In view of our last discussion, I do not believe right intentions towards the company. As a consequence, I have decided to stop our collaboration with immediate. Our judge, it was agreed. Formal letter the day after, on the 12th, which is in bundle D. It wasn't.
Tab what?
Tab 13 of bundle D.
Not the letter we looked at earlier, the
The letter
reason...
we looked at earlier is the April letter, which is the Article 60 letter. Because when Mr. Lees gets this letter on the 12th, he said,
But this letter, well, says that he's terminated with effect from the 11th. On the email of 11th, it says that he will be paid his salary up to the 15th.
problems, of course, is the inconsistency. Now that I showed you on the 11th of February, you had to sign this. You resigned to me and the auditors, which Mr. Lynette in cross-examination concedes was not. So just. That 11th of February, Mr. This same signed to him in the audit examination that never happened. You then got what in the body of that email he says he's terminated. Then got this email, the letter on the 12th of February, which refers to a wholly different email. That refers to a termination with effect on the 11:50 a.m. on the 11th of February. Now, sorry, that doesn't refer to an email. I don't know whether they were seeking at this stage or maintain the position. You then got the second paragraph as a point of clarification. Your
What happened
employment.
at 11:50? Was that the time that
That's
you
the
walked
meeting.
out?
Is that no? Because that was no. The
11:50 a.m. What happened?
sure. That was,
Well, according to page 304, last day in the office was today at 11:50. Ties in.
yes. Sorry. Yes. I'm great.
Still consistent in that respect.
But you've got the next. You see the next paragraph on 1626 where he says, as a point of clarification, your employment has been terminated as per Article 59A. What the cause is. After these proceedings are issued.
Also some reference in the documents to, well, in
No,
their
sorry.
case, I
Can I
think...
take that back? It wasn't. It wasn't after these.
Prior to what? One of the grounds that I think Stockhauser has relied on is the fact that when your client was asked to leave the meeting, then went out, as I understand it, and Stockhauser will correct me if I'm wrong, he then went out and talked to people in the office, said, I've been sacked. I don't see that addressed anywhere in your... Accept that or not?
So can I take you to the judgment?
Yes, please.
And perhaps more importantly, how does the judge?
All right, yes, okay, let's look at it.
If I could ask you to go back to the judgment then. Oh, but before I do that, though, can I just make this point? I don't know if I've made something. It is. What the final account.
He had no employment letter from the company. Employment letter from the company.
There is a finding about that in the judgment, where they say that there was a contract in 2007. What then happens is the SCA.
Sorry, where's the finding in the judgment about the contract of 2007? An assertion about that contract. There's no finding in the judgment at all.
Claimant's case below, wasn't there? Prior to the SCA in 2000.
That's on the pleading that there was no written contract.
Actually, good faith. But, you know, agreement that comes into existence when the two shareholders are reaching an agreement about how they are going to, how one party is going to acquire. Business will be managed only part of the contract of the which expressly
Appendix 3, business responsibilities.
how the run-off of the business is going, agreement between them.
Company as a party to the... One would assume the business responsibilities as set out there. Shareholders, but between... specifically signed by both parties in their... Doesn't tell you a lot.
No.
But,
whole SCA. So it's tab 15
of A1.
or A1. Look at Appendix 3, 275. One point I'll just make is if you look at in the Appendix 3, so office. 2 is an agreement between Mr. It's 9.3 and also in Appendix 3. Document envisaged in respect of this directorship, director of the company, that would continue until rather goes to the point that we made earlier. What the judge was saying about this relationship, irrespective of his employment, whether he continues to be employed. continue. In 2014. Payment is June 2015, but irrespective, the DFSA authorised person. That's indeed pleaded in the defence. The point he takes the laptop, director until director at the end of 14, sorry, April 2014, may have been terminated. He remains a director. He remains the DFSA responsibility for the accounts, and he
punchline after that.
when the judge gives his reasons, 65A, when the judge gives his reasons as to this conduct or his assessment of the conduct and taking, eyes on the fact of the different capacities, not just an employee. He says he was a director, he was the board officer, he was the director, and also rights under the SCA.
Rights under the SCA are not against the company. Rights under the SCA are not against the company, are they?
As Ms. Justice Cooke has just said to you earlier, the company is a party to the SCA.
The company undertakes no obligations.
It's still a
I used to practice in this area. Normally you don't make the company a party. If you do, you have to ask yourself why. What is the legal significance of making a party sign up to agreement where it undertakes no responsibilities?
With respect, that there's two relevances to that fact. One, if that's right, how does this form? How is this?
That's what I'm asking. Where is the contract of employment?
I've got my primary submission that this isn't the contract of employment. But you've just made, in my submission, support. The second point is that information on the laptop, the payment
Yeah, I keep on gently giving you these hints. What is the punchline? What does the company's law of DIFC say are the rights of a director?
Responsibilities as a director.
No, you have to think of the rights of the director as well. I mean, you lead up to it and then you stop tantalizingly short of the punchline.
Maybe that's something I can...
Yeah, I haven't checked this, but I'm pretty sure it will be there because it's in every other Companies Act under, that derived from the English Companies Act. Have I got it? Yes. I don't know whether I can find it immediately. The amendment. Look, let me not waste your time. What I'm looking for is a power in the company's law that says every director shall be entitled to full information on the books and accounts of the company.
Perhaps that's something again.
You can check on that
we
over
can
the
check
lunch
on that.
break, and
but
we'll
that
we'll
would go
check
to
it.
support the point. Raising it. Can I now? I'm conscious of the time. As you, I hope that we'll have seen. The point I've been making inform. Go to that. Can I just very briefly deal with some brief points on the three grounds? That's an argument and.
That wasn't very long. Also. Yeah, but
Can I
well, you're talking about the supplementary schedule. Yes, yes.
So, as I say, I'm not going to. Can I just take you, as I'm conscious of the time, can I take you to points in relation to into grounds of appeal? Can I start with the objective test? So this is ground one. And in my submission, the starting point in that regard is the case of Macduff. I'm conscious that at its volume C, it's tab 19. Tab 19, hopefully you've got stuff at tab 19. First point to note is that the trial judge in this case, trial judge, who was held in Macduff whose decision was upheld on Article 59A. But recall he was also the trial judge in Raoul Silva, which was also a judge who was coming to Article 59A for the first time. Can I ask you to turn to paragraphs, as I'll try and take this quickly because I know you take paragraphs 22 and 23, please. There you have the
50, sorry. What paragraph?
22.
Yeah, I've seen this before. Go on.
Paragraph 22 gives you the relevant test, that it's something and of reasonable responses. Paragraph 23, the construct of a reasonable employer must be given context. This is what the judge directs himself correctly, as my learned friend says in paragraph. And in my submission, I ask you to highlight the second sentence. Remote from the particular circumstances and armed only with knowledge of the conduct warranting termination. And that's the relevance of that third. I say in my submission, my learned friend's approach involves falling into that trap, arming the hypothetical reasonable officer or in the circumstances of the actual employer. The question is whether that hypothetical employer would, as a positive conclusion, terminated the employee. Gives it as an example, and it is an example only, if the employer had known of the relevant conduct for some time, asked whether an employer who had known of the relevant conduct for some time, done nothing, would have terminated the employee. Rather goes to my point where I gave you hypothetical reasonable employer in this case. I either say he either wouldn't have put himself in that position, or you inform him with the knowledge that he had acted arbitrarily, unjustifiably. Then you've got paragraph 24, and this is relevant to my learned friend's submissions, because you'll see that my learned friend in his submissions relies heavily on the two cases that are cited in the middle of this paragraph: Iceland Frozen Foods and Jones, and HIT, Sainsbury's and HIT. Those two authorities are the authorities relied on by my learned friend for his submission. This does not mean, as was submitted by Mr. Macduff, an importation of the test for unfair dismissal, law of England and Wales, by which it is asked whether the employer had a genuine belief on reasonable grounds after reasonable investigation that the employee had misconducted himself, and whether termination was within the band.
No, with respect, that's not right. I'm sorry, I beg your pardon. The transcript will show that the case that I was relying upon was the subjective intention test, which is the Madden test. The Madden test is not there referred to.
Carry on, Mr.
That test stems from legislation in quite different terms, applying the concept of fairness fleshed out by whether the employer acted reasonably or unreasonably in treating the reason for dismissal as a sufficient reason. For Article 64, whether a reasonable employer would have terminated the employee, the employer's beliefs, that conduct warranting termination is a given. Knowledge of it must be attributed. It must be found that it would have terminated. Proper understanding of the judge's reasons, I do not think he misdirected himself. And in my submission, you could apply that insofar as there is any loose expression. Apply that to this. I then take you to a paragraph you weren't taken to, but that is related to this paragraph there. Of the
judgment?
Macduff, yeah? Because you'll see that in Macduff, a similar criticism was made of Justice Madani in Macduff. The criticism was that he'd applied the common law test of fundamental breach, because if you regard the conduct as not being what the Court of Appeals say, Mr. Charles says, Mr. Trial Judge erred in conflating the contractual power of termination, importing 64 with termination at common law for repudiatory breach. It was said that the error came when he referred in paragraph 60 to the breaches listed in the letter of imprisonment not being considered to be fundamental to KBH, and that he wrongly invoked the common law concept of so far, very similar to my own friend's submission. I do not think that he did. His Honour was not addressing fundamental breach by Mr. Macduff, but whether KBH considered the breaches to be fundamental. That is, and in my submission you could say there, fundamental, that's effectively shorthand for doesn't. But in any event, that is at a particular level of significance to it. This was not invocation of a common law test, but I rely on the next words, and I'd ask you to underline these. And in any event, the common law concept not inappropriate way, is an appropriate way of giving meaning to Article 64 in its first requirement of conduct which warrants termination. So that's the effect. As I understood it, that was the point that Justice raising with my learned friend yesterday is our submission.
Some places in the judgment, which we're concerned, the judge appears to use the expressions of which complaint is made specifically in relation to the first limb. In other places, it's not quite clear what he's referring to. You may want to take us to those passages.
Will do. Can I just give you the short answer? Bearing in mind the consequences of unimportant. Maybe they mean that the employee is not entitled to their statutory right to notice. In my submission, that is why the Court of Appeal in Macduff say that the common law inappropriate way is an appropriate way of giving meaning to Article 60. First instance decision of justice, paragraph 201. Can I just take you to that? That's in at D2.
Sorry, D2, did you say?
Sorry. D1.
Which tab?
So it's tab 15, and he referred you to paragraph 201. Just to put this in context, in my, as it's clear, this is a first instance decision, whereas there is, and the other point, and you'll see it in my second sentence of 201. First instance, paragraph 37 is Court of Appeal. Another important point, in a deal, Article 59A, there was no claim for breach of Article 59. That my learned friend relies on, the concept of conduct 1682 of the bundle pagination. My learned friend took you to it yesterday, where Justice Giles does say the concept of conduct warranting termination in the article, other than breach of contract, about fundamental breach, so other than breach. Maybe there's some significance in that. Or of fiduciary duty, on which, and I would underline the words may possibly, either than either, but in any event can involve a different investigation. Ability. Paragraph 37 of the Court of Appeal.
37?
37. The common law test, appropriate way, with respect, my learned friend was struggling to give examples of where it might possibly be conduct falling short of. I say this isn't something that Giles had really to explore in this case, because it wasn't squarely no Article 59A.
Well, with respect, you had to consider whether to allow amendment to.
My learned friend will have his opportunity in reply.
Well, but if my learned friend is going to misrepresent, there was an application to include Article 59A that was the subject of the appeal. The judge, who was the same judge in Macduff, said that he was not allowing the appeal because Article 59 entailed a wider consideration. So it was directly in play, and it was the ground of appeal.
But in this case, carry on.
So, interpretation of 59A. Insofar as there is an inconsistency with paragraph 37 of the Court of Appeal decision, I say, Ms. Justice Giles says it may possibly. Can I just give you a reference, please, to the appellant's supplemental closing submissions? File A, I don't ask you to take it up because of time, but it's File A, tab 14, and it's pages 251 to 252. And you'll see that that paragraph in Macduff that I cited to you, paragraph 37, was relied upon by the appellant, by Elseco, where they cited Macduff, that Macduff passage regarding tab 14, it's page 251 to 252.
251.
251 to 252. (251 to 252), paragraph 6. Themselves relied on the passage that I'm relying on.
251, 252 doesn't have it.
Sorry, page 250. It's my
50, yes, okay.
paragraph 6. They themselves put before the judge. Roger Giles states in Macduff, the common law context is a not inappropriate way of giving meaning. And paragraph 18, they pick this up again. Halfway down, as previously submitted, the first stage of the test in Article 59A and the test for some common law are similar, if not virtually identical.
What was that about being identical?
Paragraph 18, 4 lines down. Are you on page? My submission, conduct striking at the heart of the relationship, is an accurate description of the type of conduct which will constitute cause under Article 59A, entitled there was no additional hurdle imposed. And in that regard, Brent took you to paragraph 10b of his supplementary skeleton argument. Can I just, maybe I could just do this by way of just note. Paragraph 10. How this judge, these passages. Precisely how it is, precisely what he said the judge was doing. When I deal with substitution, and my friend's point about the consideration of the reasonable employer and what he relies on, and so on, as the starting point is on substitution, is that the appellant accepts that the judge correctly directed himself at paragraph 63. My submission, even in paragraph 97, where he refers to it, follows up as to what, by reference to a reasonable employer, which paragraph he refers to, in my opinion, he expressly refers to a reason. Circumstances where he had correctly directed himself in paragraph 63, that reference to the reasonable employer still has the correct points to he's applying the right test. I've already identified that the other reference to, in my opinion, in paragraph 44, not an application of the stage 2 test, doesn't support. But in my submission, paragraph 97 is very thin ground for suggesting that a judge who it is accepted correctly directed himself, paragraph 63, nonetheless went on to apply the wrong test. But
96, where the word "in my opinion" comes, the previous passages where he's referred to the same form of words, striking at the heart of the employment relationship, taken to refer to stage 1 of Article 59A, whereas paragraph 97 then goes on to the reasonable employer point in stage.
When one reads it, a reading of this judgment, the judge has effectively found two things. Found that both stage 1 and stage 2 to accept the claim submission not so serious to warrant Article 59A.
But if you look at 63 as capable of being read as 2 and 64 as stage 1,
Yes.
bearing in mind the judge has just set out the actual terms of Article 59.
Also paragraph. Last sentence.
Yeah, that looks like first stage again.
So, in my submission on a fair reading of this judgment, the judge has actually found that both stages of the test satisfy the facts. Both findings are supported. Findings that he is with the findings of. I also can I though deal with. So as I said, the reference to conduct striking at the heart of the relationship in my submission is an accurate description of the requires no additional hurdle imposed. Sorry, I was on substitution. I hope I've demonstrated why I say there's no proper basis for saying the judge substituted his own decision. But in any event, in my submission, and it partly goes back to Your Honour's point about the man on the Dubai Clapham omnibus, who is in the context of the Article 59A, who is the reasonable employer, and how do you go about applying it? The emphasis on substitution in the authorities, and I think this addresses the point my own friend was very pattern test. The emphasis on the substitution in those authorities that he relies upon are in the context of there being a range of reasonable responses. Given that range, given that there is a range of reasonable outcomes, that in that context, range of reasonable responses. Just because the judge acted reasonably would have done one thing, that doesn't mean that another employer could not, within the band of reasonable responses, different conclusion. And that emphasis in my submission is supported by the judgments when you look at Sainsbury's and Hitt, for example. Can I give you, and that's one of the authorities relied upon by my learned friend, it's Volume C, tab 13. Paragraph 30. My own friend, when he interrupted, he made pattern test of substitution. Paragraph 30.
Sorry.
Paragraph 30 of Sainsbury's and Hitt.
Sainsbury's, right?
Yes. Paragraph 30. There, one needs to read it in the context.
Absolutely.
Sorry, I was drawing your attention to paragraph. I'd be fair. I referred you to paragraph 28. I'm sure. my judgment, the appeal tribunal have not correctly interpreted the impact of the decision of the court. The range of responses test, or to put it another way, the need applies as much to the question whether the investigation into the suspected misconduct was reasonable also, and as it does to the reason. The point the Court of Appeal are making there is that it's in this context of the range of reasonable responses. And I'd also ask you to read paragraph 29 as well. Primary submission is that there is no.
Case and Madden were interpreting.
Section 98. Point that Your Honour, in reference to, you see they cite this case, Sainsbury's. That makes the point.
Right, your point is Madden doesn't apply.
And so my learned friend's emphasis on substituting your own opinion.
Right, yeah, so you're saying ban of reasonable responses isn't an applicable test here.
I'm not saying that. The Court of Appeal and Macduff have held that. And of reasonable response is not. Recognises that there's a range of reasonable. The judge takes the view range of reasonable. What would the reasonable employer and in any event about, well, if there is only one answer, how do you apply that? Ground of substitution in this case isn't made. Can I deal with Brando, the unjustified departure from Brando? I've already referred you to the fact that the judge recognised the Brando statement, paragraph 61. So this is recognised that in normal circumstances, Brando would mean that retention of a laptop wouldn't be justified. But the particular facts of this case didn't provide cause for termination. In those circumstances, it's important to act Brando, what Mr. Justice suggests. And that is behind tab 14, volume C.
So we're going back to the judgment in this case. coming back to Justice Al-Madani's judgment.
No. Brando,
Yes, and that is
Volume C, tab 4. See, my own friend took you to paragraph 23, which is paragraph 23 is at page 1383. See that the second sentence expressly says, I should not get drawn into any wide statements of principle which are unnecessary. What he says is, I am doubtful if the possibility of litigation with an employer could ever justify an employee in transferring specific loan retention which is relevant to such a dispute. All of the cases relied upon by minority purposes of future employment. Bringing a claim against the employer, banking these documents was the phrase used in Anand. It's banking these documents for his use. Immediate point of distinction in our judge refers to the fact that at least part of the reason for taking the laptop and the information indicate his conduct, fraud that were being made against him. And as I say in the supplementary skeleton, I ask you to carry on reading. He says, it talks about if the disputes, that's an employment dispute, not a criminal dispute. If the employment dispute arises, you've got the point about disclosure. But then there's this point that I don't think you were taken to yesterday. Paragraph 23. I'd ask you to underline this. Nor, in the absence of a specific issue, was Chadwick entitled to transfer his own position in case a regulatory dispute might arise. Envisaging that if there was a specific regulation, that line, sentence, needs to be read. Paragraph 18. The judge says, the purpose was to arm herself for the future in any at Brando or with the regulators which might arise. Omar, so that's the employment dispute. But do you see that? 3 lines, 3, 4 lines. There were not then any problems with the regulators, nor have any arisen since. Nor could Miss Chadwick, in her evidence, provide any convincing grounds that they might arise. So that ties in directly with the law sentence in paragraph 23. Contrast the position in our case. Fraudulently inflating these accounts. Moreover, was a specific issue. Judge finds in paragraph 65D, talks about taking the information to vindicate his conduct. Like, Justice Jack relied on the fact that regulatory issues had even arisen. But in this case, Mr. concern about the criminal allegations came to pass. The employer did raise criminal complaints with the prosecutor in relation. Immediately, the distinctions with Brando and why it is important, even for an examination of the facts. Can I take you to some other paragraphs that you weren't taken to?
What kind of a complaint was made? I'm just thinking out aloud that since accounts for 31st of December 2013 were eventually excluded the items that Mr. Lee's wanted to have included, would not have been able to create any accounts which would be subject to the criticism of not giving a true and fair view.
Quite.
So I'm just a bit puzzled by how yeah, I mean, unless you're talking about a case where it's an allegation.
It was he prepared. I'm told that the allegation is that it was that he.
Well, it depends what you mean by prepared again. I mean, what goes to the auditor basically for consideration is the overall P&L
With respect,
and the balance sheet. And unless it is alleged that the primary books of account have been falsified, then I can see that there is an issue about fraud.
As I say, that arose through the allegations being made. But my point for raising it is that's precisely what Mr. Paragraph 18. There was no specific regulation in Chadwick's mind, and indeed one she couldn't, and one never came to pass. In this, also, you've got the findings. There was the criminal allegations of fraud being made. Got the fact that the judge says that all the hundreds of emails would vindicate his conduct. The fact that the allegation was made, and Mr. So that the allegations that were being made were unfounded. Can I just very briefly, in our skeleton argument, we refer to paragraphs 31, 32, 44, and 45. Weren't taken to those. Can I just do this by way of sideline, please? 31. Oh, sorry. After the statement where he says about whether you're justified in taking the material, he says, you've got a heading. Was Brando entitled to dismiss Ms. Chadwick summarily? So immediately you've got the point that just because you doesn't a fortiori lead to the conclusion. What he says is, first sentence of paragraph 31, do you have it, Your Honour? Paragraph 31, Mr. Justice Jack?
Not yet. Brando, is it?
Yes, paragraph, tab 14.
One.
Yes.
Yes, I have it.
Held that Ms. Chadwick's conduct was in breach of her contract. The question then arises whether her conduct was so serious that Brando was entitled to dismiss her summarily. So there you've got immediately, there is no rule. After he set out the passage. Then you've got over the page at 1387. Paragraph just above paragraph 33. Just in that paragraph, however, this five lines down.
33, is it?
Yes, no, it's 32. It's just immediately above paragraph 33. It's about 10 lines up from the bottom of that paragraph. However,
quotation from after the quotation from Talat.
Yes. 5 lines down from the quotation. However, the seriousness of what Miss Chadwick did, so that's the retention of the document, is to be judged in the context of her employer's conduct towards her insofar as relevant. Take a straightforward example. The seriousness of an employee's conduct in swearing at his superior may be affected by the fact it was in response to the superior himself swearing at the employee. I would like to emphasise so far as is relevant. And the judge's findings of fact. With respect, it also expresses would have influenced the way the judge dealt with the response after the exclusion. We'll come on to that briefly, but can I just finish off on the judgment, please?
Yeah.
Could I, paragraphs 44 and 45? Just some high. My submission 44 is helpful just in terms of the test. You'll see in the quotation in 44 at paragraph 63, it makes the point that whether or not there has been a repudiatory breach is a highly fact-sensitive assessment, and you've got the judge in our case saying, on a careful review of the facts, he reaches. Paragraph 45, Miss Justice Jack says, the motive of Miss Chadwick, do you see that at 1393? The motive of Miss Chadwick for acting as she did, that's taking the information, is most important. Again, a few lines down, he again makes the point that there may also have been an element of protecting herself if there were problems with a regulator, but there was no reason to anticipate a specific problem. In our case, you've got my point, that in our case, as the judge found, to be concerned about the criminal. Could I ask you, then I think this I might have to.
But factual terms, I was holding company's financial information on the company laptop. Entitled to do for the course of his employment up to, let's say, at least 11th, possibly the 12th. Yeah. Right. Different from these cases where there's a transfer onto a private, and isn't there somewhere that you're that all of the information from the laptop was derived from the company's accounts, which were therefore backed up?
It's a slightly different point, and I'll deal with this now as you've raised it, because my own friend made great play yesterday of the fact that...
I have a lot of time to make your point. That's why I wanted to get it out.
I'm grateful.
I still want your cross appeal, and I think 18.2, frankly, you might as well leave it to us, because wait for the judgment to come out in front line, and then you'll take it from there. I'm grateful.
Can I deal straight with Your Honour's question? My own friend raised yesterday, he expressly said that he claimed that all the data was wiped and destroyed all of the information. And he sought to rely on that, and he criticised the judge for not making a finding of fact on that, in relation to a matter bearing in mind that postdates termination. This is addressed in our appellant skeleton argument, but the short answer is it was the claimant's unchallenged evidence that he had backed up the contents of his laptop onto Elseco's server. So the express suggestion that my learned friend made yesterday, that the claimant destroyed this information to cover his tracks, is inconsistent with the unchallenged evidence challenged on this. Elseco would know that backed up the information on the laptop onto the claimant, onto the Elseco server. There's also his unchallenged evidence, and this is important, he was not cross-examined on this issue, gave unchallenged evidence, and it's in our skeleton argument. He gave unchallenged evidence which was corroborated by third-party evidence. There's a appeal bundle. Corruption that happened to the computer was an inherent Apple fault. It wasn't the claimant's conduct basis that he had destroyed the laptop. So in my submission, there is absolutely nothing in that point. It's simply wrong to say that he deliberately destroyed the information on the laptop to cover his tracks, and the inference that my learned friend sought to ask you to draw, no basis for it, my submission. The references in the claimant's witness statement are paragraphs 128, where he says it was backed up. 195 is in relation to the fault. It deals with the laptop, and tab 14 of bundle 8 is the email that was before the trial judge from the computer provider. Bundle D, tab 7.
Bundle
D, tab 7. What? So, and I say these references are in our skeleton argument where we address this point about being backed up and so on.
The only paragraph mentioned is a paragraph 125.
I've given you the references.
Sorry, could I have them again then? 128, 125.
128, 125, 195 to 204, and tab 14. Tab 14 is the email. Bearing in mind that the 11th of February email records Mr. Lemaire records that the claimant had told him that he would return the laptop. What was in his mind at the point of termination? In that email terminating, he says that Mr. Lees had told him that he would return the laptop. Can I deal very briefly with, so A to D? Relevant factors. I just deal very briefly with the judge described as the other minor conduct. That tells you what the judge's assessment of the other matters were. He describes them as minor. In relation to the allegation about non-solicitation, he finds no solicitation. In relation to the allegation of outside business interests, based on Mr. Lemaire's evidence that he was aware the trial judge finds no misconduct in relation to the work. All that leaves is the other minor reasons. At page, back in the judgment, internal numbering 26, thank you. Paragraph 87, he there describes them as less serious causes. So these are the allegations. Then see over the page, he identifies the dispute between 89. Unchallenged, you'll see that denied the defendant's allegations. You'll see what it says there. About what he said at 91. And 90. And 94, in my view, none of the reasons provided by the defendant amount to gross misconduct. Referred you to 95. 96 is important. Claimant's behaviour might not be what the defendant was expecting, but it is in no way, in my opinion, actions that strike at the heart of the employment relationship. I would emphasise that gravity of this conduct. Bearing in mind, all of this takes place against the backdrop of the judge finding that the way Mr. Lemaire so how the claimant reacts, that's my Brando point about when got to consider what was he responding. These were effectively former, this is effectively previous co-owners. You've got unjustified, arbitrary allegations of fraud being made against him. You've got the fact that the judge says he's excluded from a meeting. How he responds has to be viewed in that context. And in my submission, that explains why the judge says it is in no way. That gives you insight into the judge's views of the reasonableness. Can I ask you to just make a note, please? B1, pages 364 to 366. See that there the claimant's justification for retention expressly advanced as defending himself against criminal allegations being made.
Right, B1.
So, I'm conscious of the time. Can I just give you the reference for you to make a note, please,
Okay.
to look up? B1, and it's pages 364 to 366. And I ask you to look at paragraph 7 of the defence. Again, if I could ask you to make a note, it's A, tab 7, 106, where you'll see that the pleaded Article 59A reasons was the manipulating the accounts and the devotion of time during his normal working hours to the marketing and establishment of his own business. Those are the two pleaded Article 59A. I also just point out Clause 8.2 of the SCA, whereby the claimant has a veto right in his capacity as director up to the completion of payment date, defined as the 15th of May 2015. As you know, paragraph 7 of the defence, as I've said, doesn't rely on the retention of the laptop. In my submission, the judge was right to take into account that it was not the primary reason for dismissal. This is not a GMB packaging amount, a packaging point. It's relevant in the assessing the seriousness of the conduct to consider how how this employer viewed the laptop in the context of the other matters. What is it that he's relying on in the Article 60? Very specific reason, the accounts. What does he rely on in paragraph 7 of the defence when he pleads the Article 59A reason? Can I just say, in relation to paragraphs 97 to 98, in the judgment, paragraph 25, in my submission, that supports the fact that he is looking at these matters cumulatively, because he identifies the purpose of the examination is to look at whether any or all of the conduct alleged justifies or all. My submission, paragraphs 97 to 98, is a general conclusion on the Article 59A issue. He says, thus the above-mentioned reasoning and discussion, i.e., in my submission it's paragraphs 26 to 96, takes us to the conclusion that the defendant has failed to satisfy this court. Properly read, actually, 97 to 98 is that overall washback. Because he sits back and he finds, well, and you've got to look at, well, he didn't find, certainly not misconduct, the Article 59A standard. Can I give you another reference? Volume A, tab 13, pages 244 to 246, and that's paragraphs 29 to 35 of the claimant's closing submissions, tab 13, 244 to 246, paragraphs 29 to 35, and in my submission that neatly encapsulates what the claimant's case, which we say the judge accepted, were the reasons why he retained the laptop and why that would not warrant termination. You've got our respondent's notice in my submission that deals with why. Can I just make this point about 2 points about Article 18? I know a friend has handed up for his formulation. That is expressly the formulation. Has addressed that as to why that work. Can I also, though, refer you to an authority that I don't know if it was discussed in Adil, but it's page 131. Can I do it in this way? Paragraphs are Lord Reed at pages 1311 to 1314. You might find this helpful because in that case they were dealing with a tax penalty. The penalty is to not. In that circumstance, you'll see, say you've assessed yourself for, let's take an extreme, but in fact, they were saying, because on the strict on the wording, you've got to say it's only £1 out. You can't. What Lord reads, and they go through those types of extreme examples, and they say it may be that this produces, but that's the wording of the statute, and it's for Parliament. My submission, Pinch, is relevant to your consideration. Can I deal very briefly with the cost? Briefly in my submission for this. Deal with why we should have. As far as we still need permission. In the response to our cross-appeal, the relevant statutory provisions what my learned friend's submissions are, going through those provisions. Our case in detail. Straightforward reading of those provisions. I think, Your Honour, in Adil, when you were looking at these provisions, although it wasn't strictly an issue, you raised with the advocates in Adil the fact that wages includes bonus, and you were positive whether it might also include share options and so on. Can I make this point on the bonus? You'll see that in bonus, you'll see that there is a previous years provides for 50% of salary. In this final year, it says 20% to 100%. So a baseline of 20. So the minimum he's getting is 20%. This remuneration package, that the bonus was a critical, as you often see in of high patch is more weighted in bonus than the base salary. You're looking at the definition of daily wage. It's clearly right that in calculating the daily wage, but under the legislation, total compensation, including our submissions on those provisions. As I say, in respect of interest, can I just make this point? The draftsman could have used basic wage. And in fact, the judge in this case ordered that so when he came to make the decision about the penalty, he ordered that the full amount of the bonus was payable. Oh, can I make this point, sorry, about Article 18, the substantive point that I should have. In our supplementary skeleton, indeed, by looking at our supplementary skeleton, please. Bit of our supplementary skeleton argument that deals with the friend skeleton, supplementary skeleton. Do you see at paragraph sorry, I'm in the wrong. It's Appeal Ground 2, it's paragraph 8. We say, although the appellant's supplementary skeleton argument addresses the part of paragraph which referred to as Elseco does not address the main part of that paragraph. Answers, Mr. Lees was entitled to the penalty. In its amended defence and counterclaim, it admitted Mr. Lees was entitled to various sums, yet as at the date of the hearing, and indeed at the time of filing the original skeleton argument, but in fact we know those sums and the bonus that was ordered, they were only paid pursuant to. The point is made in the appellant's skeleton argument, oh well, these were all paid on the 30th of October. The point that's not made is that that was the result of a statutory demand, which you have in. You've got a reference there at the end of paragraph 9. Lees was forced to issue a statutory demand to get those sums. Isn't that precise? Article 18 is in avoid. Can I just, in relation to interest, you have the short point. Both parties. In my submission, as the divine laws
It's IBOR. IBOR. What is the currency?
Effect of these sums.
Yeah.
They're a mixed bag, I think. Dollars and dirhams, I think. It's just a jealous attraction much about that. Whether a payment will ever be paid and what the amount is. Well, is there anything that I've not addressed that you
Yeah, two questions. One is, how many directors were there in the company?
No.
At the time of Mr. Lee's dismissal?
At the time of dismissal, 2. Mr. Lees and Mr. Lemaire?
Right, Mr. Lemaire and Mr. Lees, right?
Yes.
The other thing is that, do we have all the figures of the... There is no appeal against the actual calculation of the numbers in Al-Madani's judgment. Right? You don't have to recalculate anything, except have you got a figure
I can hand up the counterclaim.
you have
So the cross appeal. What we've done is I've just got a single sheet of A4 that sets out the mathematical basic wage, what the calculation would be to date, if it's the... and what the daily accruing rate is, of course. The other point I was going to make is that in one of the cases we've referred to, on interest, is of course penalty as well.
Sorry, I haven't seen this.
Yes, it's the arithmetic.
You can come back, later after we adjourn, Mr. Hockhauser. So if there's any disagreement about this, we were likely to send it for determination.
But could I just ask for one point of clarification before the court rises for the short adjournment? On these figures, is my learned friend calculating the bonus payment from which date? February of 2014, when it wasn't awarded until following year? Right, so it's
For
being
the date
counted.
of the declaration of the bonus, right?
No, it's not. As I understand it, the calculation, this is why I asked, these figures seem to import an entitlement to a bonus that had not yet been awarded and was not awarded for some 15 months. Yet the figure imports that.
I didn't get down to asking it, but I noticed that the bonus, according to the agreement, was to be determined in 2015.
No later than June 2000.
And it was, in fact, delayed until then.
And then what happens? So what happens? These figures, so we are clear, what my learned friend is saying is, despite the fact that the bonus wasn't awarded until June 15, they include an entitlement factored in from February 14.
Right, February 2014.
So it's bringing it back.
Meaning the date of his dismissal.
That's the definition, because insurance claims and so on. Given the way it's framed, the court really is not zero.
I have found the relevant provision of the company's law. It is in the 2009 company's law, Article 101, but that was amended in 2013. Company's Law Amendment Law, which is the IFC Law 2 of 2013. The relevant article is 101, and it basically says in the first subsection, every company shall keep accounting records, including underlying documents, that's the amendment, which are sufficient to show and explain its transactions so as to enable directors or managers to ensure that any accounts prepared by the company under this part comply with the requirements of this law. Sub-article 2, a company's accounting records shall be ABC, So 2C says, open to inspection by an officer or auditor of the company at all reasonable times. At all reasonable times was the amendment. So there you are, make what you will of that.
Can I just make this other point, though, is that in addition to that, this is genuine concern that as a result of an arbitrary behaviour, those underlying information.
He had a fear that the underlying...
Genuine, yeah.
Might have had a genuine fear.
Okay. We'll come back in an hour, so it's, we'll come back at 2:10.
Grateful.
All rise.
Time goes quick. I've got instructions. There's not really-
As I said yesterday, I think we need to finish in a couple of hours, so an hour on each side is now coming,
Well,
up to 2:15.
Your Honours, I agree with my learned friend that given that he has only got a right of reply on his cross appeal, that he kindly agreed that I could have an hour and a half to deal with the reply to the points that he made this morning. I'm not sure I'll need all that time, but he was kind enough to say that because the cross appeal is within a very narrow ambit, as you will be aware. Could I start, therefore, with the cross appeal and deal with that quite quickly? Before I do so, could I just ask your lordships, do you have a copy of the amendment to Article 18? You asked me to produce something in writing, and I did that overnight. It was on your desk.
Is it headed note to the court?
It is. So that deals with the clarification that you asked by reference to the ICS case. Dealing first with the daily wages point, could I take your honours to volume D, tab 6, which is the appellant's notice to the cross appeal, and ask you to turn at page 1556 to paragraph 12. It's in volume D, tab 6, which is our notice to the cross appeal. And could I first direct you to the extract from Mr. Leese's opening skeleton in the court below, which is there extracted. For your reference, it is volume A, tab 9, page 171. So if you look at paragraph 12, the opening words are at paragraph 88 of the opening skeleton. Do your honours have that?
Bundle A.
No, bundle D, tab 6, page 1556. Our notice to the respondent's cross appeal. So my first point that I make is that that was what the judge was asked to award, and that is what he awarded. There was never any change during the currency of the trial, in closing submissions or before he made his order, to invite him to reconsider that. And remember, it was a year that passed before he handed down his judgment and his order, nearly a year. At any time, had this point been one that should have been taken, there was more than ample opportunity before the order was made, and it was not. So effectively, when one looks at paragraph 14, he accepts that what is being proposed was not advanced before the judge at first instance, and in fact he's appealing the very decision that he successfully saw. And in my submission, that is not a permissible activity. And indeed, if one posits a case that if there had been no appeal, he would not have been able, after the order had been made, to come back and invite the court to reconsider it. So we say that this attempt, after the order has been made, is an impermissible exercise. Now, if which is denied, he is entitled to run this argument before you. It is our submission that he should not succeed on it. If one looks at volume A, tab 6, I'm sorry, that's a wrong reference. This is Schedule 1 to the DIFC, so it's volume C. Beg your pardon. Tab 6, at page 1268.
Still the same bundle?
It's volume C at tab 6. This is the authorities bundle. This is the DIFC employment law, Your Honour. Basic wage is defined as the wage excluding any portion of an employee's wage received in kind or as allowance for housing, travel, currency exchange, children's education, social and entertainment, or any other type of allowance, bonus, commission payment, or overtime pay. So there is an express exclusion under basic pay of bonus. Daily wage is silent. If you drop down 4 of the definitions, daily wage appears there and makes no reference to bonus expressly at all. Now, at the date of termination, no bonus entitlement had accrued. And if you turn, please, if you put away volume C and take up the judgment, it begins at page 28 of the internal pagination, at paragraph 100. And it's clear that this entitlement did not crystallize until June of 2015. That was not challenged. That is what is provided for under the SCA. Because the judgment was handed down in 2016, in July, that date had passed. It was therefore awarded. However, in my submission, that cannot be factored into the entitlement of the claimant, first, because it is not provided for in the law, and second, because, and the absurdity of this position can be seen from the calculations that my learned friend handed up just before the short adjournment. Imagine this scenario, that on the 11th of February, the employment is terminated. There is an entitlement, for the sake of argument, to receive a payment after the 15 days post-termination. How can there be any entitlement within that figure to a bonus that has yet to accrue? Because suppose the employer, after 2 days late, following the 15th day, makes the payment that is due at that stage. How could that include an element for a bonus yet to crystallise a year hence, more than a year hence? So the idea that you retrospectively calculate this and look at the figures, I mean, this is a man whose employment was terminated 3 days early. And what is now claimed for that is €820,000 and continuing at a daily rate of €831. And in my submission, 1, the claimant should not be entitled to raise this now. 2, as a matter of proper construction, it is not included. 3, it cannot possibly include a matter yet to crystallise and retrospectively operate in that fashion. And for those reasons, this invitation should be declined.
Looking at the respondent's calculations, under daily wages, is this the figure that actually ordered by the trial judge?
No, it wasn't. In fact, you just the daily wage that was awarded, I believe, was 297.35, which was the figure that was asked. So I'm afraid I'm not. But I'm afraid I didn't understand that, because what was awarded by the judge was the daily wage pleaded at paragraph 88 of the claimant's skeleton argument.
Ask Mr. Novak just to explain that.
Yeah, very briefly. Following in this appeal, calculated the was that the basic salary over the 365 is the correct, as it were.
Well, my Lord, what I say to that is that, again, a similar argument is to be advanced, that if there was to be an invitation to the court to take a different approach, the claimant had over 11 months from the date of argument until the order was made. It was not. The order has been made, and as I say, the award that has been made in that regard is exactly what the claimant was seeking. So the like argument applies to the recalculation of the daily wage as much as it does to the one including salary. So including bonus, forgive me.
What's your point? Yes.
Thank you. The next point I make is in relation to interest. And sitting on your desk is the practice direction, number 1 of 2009, which is referred to in our skeleton. That is to be seen in the respondent's, the appellant's notice to the respondent's cross appeal. This is referred to at paragraph 19 of at page 1557 of D6. And the critical words are that a judgment shall carry interest from the date that the judgment is entered at the rate of 1% over the EBOR, which the learned Chief Justice referred to before the short adjournment, at the rate of 1% over that rate, or such other rate as the judge may prescribe in the judgment. Now, the judge has a discretion as to the costs that he is going to award, and it may be felt that since he was of the view that his construction of Article 18 produced, on occasions, absurd results, rather than give a more generous rate of interest, he was going to limit it, as he was entitled to. He was certainly under no obligation to accede to the rates that were being advanced by the parties for their respective claims and counterclaims. And I accept that in the pleading, each party did advance the rate of 8%. Although I have to say that when I looked a little further into this, we changed our stance to a lesser figure. If you look at volume A at, forgive me, tab 10, at page 192, my predecessor, Mr. Kemp, in his skeleton, is the opening trial skeleton, at paragraph 70, reflected the practice direction. So our submission is, as can be seen from the respondent's notice, I beg your pardon, the appellant's notice to the respondent's cross-appeal, that the judge had the discretion. He awarded 1%. He was entitled to do so, and there is no basis on which this court should reopen that matter. So those are my submissions. And I'm told that the EBOR rate is available on the UAE Central Bank website, and the 3-month rate is currently 1.33357%.
The IBOR rate cannot be more than one IBOR rate.
Yes, I mean, what I've just given to your honours is the 3-month rate.
No, what I mean is, first of all, is a period. Aren't there different rates for different currencies? As with, and LIBOR and SIBOR and
I would certainly imagine
IBOR,
so.
all of them have different rates for different currencies.
Yes.
I don't know whether UAE is different.
The answer is I can't tell you without taking instructions, but
anyway, we're fixing at one. I mean,
exactly.
It's flat.
Yes.
So it's academic.
But,
I mean, if you're right, then it's academic.
that is my submission. So that deals with the cross-appeal. Can I therefore turn? Obviously, I won't address every single point that my learned friend raised over 3.5 hours. I won't have the time to do it. What I would say is, you have my earlier submissions orally. You have my submissions in writing in the first skeleton and the reply. Have you looked at the supplemental skeleton, or have you had the chance to read it since receiving it? Thank you very much. Well, I will therefore take those points as read. The first point that my learned friend makes is that the submissions that I have been making go beyond the grounds of appeal in their scope. In my submission, this is not an attempt to do exactly that. If you examine carefully the grounds of appeal, you will see that there was a challenge to the judge's approach in the application of Article 59A, both in fact and in law. The 3 matters that are identified expressly challenge the basis on which Brando was distinguished. And the inaccuracy in relation to one of those grounds is expressly referred to in the supporting skeleton at paragraph 10b, which for your note is A, tab 3, page 13, and in paragraph 30 at A24. If I could just take you to that at A324. There can be absolute, and this was served.
A doesn't have 24 tabs.
Sorry, it's A3 at page 24. This is the skeleton. You may have it. You may have taken it loose.
I've got a loose copy. This is of your main skeleton.
It's our main skeleton, not the supplemental one.
Right. The one with suggested reading.
I've asked you to look at paragraph 30. This skeleton was served with the notice of the grounds of appeal and bears the same date as them, of the 28th of July.
Sorry, I've got a later one now.
So it is quite...
Sorry.
I'm sorry.
I keep on coming back to your skeleton of 18th of September. You are talking about the skeleton before the trial judge?
No. Well, I'm talking about the skeleton that was served with this notice of appeal. It's dated the 28th of July of this year.
That's the one when you have your application for leave, isn't it?
This is the one that was submitted with the application. It is the one that appears in
so
tab
anyway,
3.
Let me...
Don't worry.
Bundle with that.
It's at tab 3.
Saying A3 or
A3.
A1?
No, sorry. It's volume A. There is no A2. It's volume A1. I'm sorry that there's that confusion. It's in volume...
I now have it. Sorry, thank you.
And it's paragraph 30, at page 24 of the bundle. And it bears exactly the same date as the grounds of appeal. And we challenge the facts and circumstances that are set out in paragraph 65 and make it clear that one of those grounds is that there was an error that was made by the judge. And I'll come back shortly to the references which really reinforce that this was a central part of the judge's finding, that there was no explanation forwarded. And just to bear that in mind, my learned friend helpfully took you in his submissions to another paragraph in the judgment that dealt with this. If you look, please, not only at paragraph 65D, give me 1 second. If you look at 95, at page 70, internal page 27 of the judgment, I'm referring now to paragraph 95 of the judgment. He says in that paragraph, just as he had in the earlier 65D, the importance of his entitlement to attend the meeting between Mr. Lemaire and PwC, at least till the ends of the accounts discussion. So, Your Honours, what I say is that this ground of appeal and that point by challenge to the evidence and the finding of the judge is one that was made clear. There is also an assertion in the grounds of appeal that the matters, the behaviour, needs to be looked at in the round. And I repeat my reliance on GM packaging. there was, in our submission, a failure on the part of the judge to consider the alleged misconduct as a whole. And my learned friend's attempt to rely upon paragraph 97 of the judgment as indicating that he performed that exercise is, with respect to him, one that is not factually founded. That conclusion there contained was reached only after a segmented approach had already been adopted. And that segmented approach was exactly what GM packaging counsels against. It is an artificial examination of the claimant's conduct. There was an obligation on the judge in our submission to resolve the disputed facts, to set out the relevant narrative, and to consider the matters as a whole, applying the correct test. And that did not happen in this case. When we come to look at the accounts and his stance in relation to them, there is a degree of artificiality, because to consider the claimant's expert evidence as indicating that making inquiries is standard practice ignores the fact that the person making the inquiry had himself a vested interest in the outcome. And my learned friend took you through the various documents. I won't repeat the process again, but I would just draw 2 points to your attention at B and C. Please remember that as far as B is concerned, nobody within the company, including Mr. Lemaire, received item B, which is at A16 of the documents, and that Mr. Lemaire did not receive the document at 45C. The quote that is given at paragraph 45D unfortunately doesn't give the full answer there quoted. Could I ask you to take it up?
What else to look at now?
I'm asking you to look, please, at volume B2. And this passage appears at 801.
You mean B2, right?
I do mean B2, because there are 2 volumes. So this time I do mean B2. And it's not a tab, it's a page 801. In fact, it's within tab.
Fine, 801 would do.
So you will see that the passage that is recited in the judgment ends, if you look at the last answer from Mr. Lemaire by the hole punch, no, I don't think he could. This is about forcing the auditors. The answer continued. I think it's important, referring to what you said yesterday, to include in the reflection DIFCA a bit, even if it's not the right court for this. But he was trying to push a new methodology and create a bit of a clash out of it in order to be able to claim on the arbitration side more money. Now, that does not appear in the judgment, in the recitation of that answer. My learned friend said he was going to take you to it, and I'm sure under his pressure of time he wasn't able to get to that passage. But that is a critical answer in my submission, which indicated why he regarded this exercise as being one that was not appropriate for him to do, certainly behind his back in terms of sending those communications to PwC at letter B. Now, in terms of the accountants, again, my instructions are that there are no external accountants. There are internal accountants, and there are PwC, who are the auditors. And that is the position. There is no third-party accountants who are external as such.
So I'm just querying the distinction between accountants and management, but never mind, it's a small matter. But, you know, I'm trying to understand Mr. Lemaire's point of view, making this statement, sense that what did Mr. Lemaire expect Mr. Lee doing? Mr. Lee was CFO. He was responsible for preparing the annual accounts. He prepares them to the best of his information and belief. He may or may not have a, how shall I put it, 110% belief in his view about the 5.2 million, but it would align with his own interests, and he has an opinion on it that it is a justifiable amount to record for the 2013 financial year. So he puts it to the accountants. Whether or not he believes in it actually is not terribly material, because at the end of the day, it is the auditors who have to look at it and see whether or not it's properly entered. So either they say yes or they say no. I mean, if he didn't include it, it is even theoretically possible that PwC could have asked him to include it, saying you're under-declaring. Right? So what do you expect him to do? I mean, to stand aside from that whole exercise because he has got a vested interest?
No, I don't say he has to stand aside from the whole exercise, but there are certain salient points that immediately come into focus. He is coming to the end of his term as CFO. He stands, if his suggestions are right, to get a substantial sum of money. The complaint that was made by Mr. Lemaire is that these matters were being raised in the way that they have been described at 45B and C without his knowledge, and whilst he was away for part of that time in Luxembourg. So he was not copied in to certain of the communications. The significance, and I hadn't drawn this to your attention before, is that
there were other communications, were there not, which put him into the...
Well, can we see what they were? Because if we look...
Before, Mr. Hockhauser, just to check with Norbath, you don't dispute Mr. Hockhauser's statements of fact that there were certain communications between your client and PwC which were not provided to Mr. Lemaire, right? Not copied to Mr. Lemaire, right? So that's common ground.
The judge deals with this he goes through 45A through to E. 5A is the starting point, which is copied. It does go to Mr. Lemaire. Cross-examination that I took you to this morning, where Mr. Lemaire...
I thought you had 3 documents which went to him. The 3?
I have to go through them. It's certainly 45A and D. D. The documents at 45A, 45D. E goes to the, and I'm told, sorry, that my learned friend is right when he says about there are no external accountants. Is the internal accounting team. So although it doesn't go to Mr. Lemaire, it goes to the accountants, the internal management. So it's E. C goes to is internal. D goes to Mr. Lemaire. So those two, and you recall the cross-examination this morning where Mr. Lemaire said that on the basis of the information documents he was sent at the end of January, he did see at the end of January, he concluded that there was a left it 2 weeks. So the point about no as at the 20th.
Thank you. Back to Mr. Hockhauser.
So I come to the. So my point is that there were salient communications that were omitted, and the figure of 5.2 million drawn to the attention of the accountants was not drawn to the attention of Mr. Lemaire. All he had was the statement that appears in A. Recognition of revenues for launches postponed from 2013 to 14. Now, I come to the meeting itself on the 11th of February, And what is said by my learned friend is that the judge's finding at paragraph 65D, can we turn to it? Just 1 second, please. That he didn't have the opportunity was an implicit rejection of Mr. Lemaire's evidence. Now, there are difficulties in my submission with that. Not least is the failure to set out a full narrative of exactly what happened and where the disputes lie. Again, I draw your attention to paragraph 14 of the judgment, which sets out the defence case, but importantly makes no reference to him being invited back into the meeting. And my learned friend took you to certain passages in the evidence today. Could I ask you to take up B2 again? There are two passages that I would show you which suggest that this was absolutely live. I've taken you to the material passage in his evidence in chief, which is reproduced in our skeleton argument, where he says it in terms. Now, my learned friend took you in B2 to page 772, and Mr. Dar, at the foot of that page, asks him, you didn't give Mr. Least an opportunity to explain himself, did you? Answer, I did. I gave him 10 days. Turn on in this, if you would, to page 849. Because, again, indicative that there was an opportunity to explain given to him, Mr. Dar puts the question to him at 849. By Mr. Lease, when you narrowed down...
We've gone to a different page now?
We're on page 849. And I'm looking at the question by the second hole punch. In fact, if I can take it a little halfway down the page, Mr. Dar says, can I also suggest that you had a substantial number of questions resolved to your satisfaction at the meeting on the 11th by Mr. Lease? By Mr. Lease, no, sorry. And then Mr. Dar says, by Mr. Lease, when you narrowed down the figures, can I suggest to less than 2 million? It was clear that he wasn't suggesting that the entire 5.2 million be included in the revenues, was he? And look at the next answer, please. It's clear at the end of the meeting he didn't suggest to include the 5.2 million. Now, that is entirely consistent, both as to the question and the answer, with what was said in the evidence in chief. And I again draw your attention to the finding at 65D and the reference at paragraph 95 that he was entitled to attend the meeting at least to the end of the accounts discussion. And they form a very important part of this judge's judgment. So in my submission, that was a central feature. It was wrong. It was not a rejection of the evidence because the case wasn't recited. It was an omission, and it was an important omission because it caused the judge to proceed on an incorrect basis. At the very least, he should have resolved that dispute between the parties. Now, I come to the SCA. In my submission, the SCA is an important document in relation to the employment relationship. I rely upon the fact, as pointed out by His Honour Sir Jeremy Cooke today, that this was a document to which the parties and the company were a party. It included an aspect which ran the day-to-day business and ascribed obligations to the parties towards the company itself. That goes beyond the parameters of a normal shareholders' sale agreement. And the fact that the company was included and the way in which those two schedules, together with Clause 9, is framed, means that this fulfills a number of roles. It deals with the regulation of the sale of the shares, it deals with the roles of the parties vis-à-vis the company, and it deals with the terms under which they will be employed. It is a multi-purpose agreement. It is one that was relied upon by the defendant. It was relied upon so far as it was said the original contract was varied, and I've taken you to the pleadings in the particulars of claim, where it is accepted that this employment relationship was varied by the terms of the SCA by reference to Appendix 2. It is my submission that you can't hive off Appendix 2 as being the only content. You have to look at the body of the agreement insofar as it is relevant, and the relevant terms are to be found in 9.2. Now, you asked what were the references in the document itself. Unfortunately,
Yes, can we have that document again, the SCA, please? Could we have the document reference again, please, the SCA?
Yes, of course, it's A15.
Sure. Thank you.
Sorry, Your Honour. So the 9.2 references, I'll just give you two. In the opening submissions, it's A10, page 176, and in the closing, it's A14, page 251. In the actual body of the agreement itself, could I just direct your attention to 9.2 itself at page 266. Appendix 2, which deals with salary packages and employment contracts for both individuals, and Appendix 3, business responsibilities. Can I also draw your attention, whilst we're on this bundle, within tab 15 to 292C.
Right.
Whilst we're looking at this section, tab 15, could you also look at page 292C? It's the one we're looking at, the SCA. We're still looking at the SCA, Your Honour. 292C. It's 15A, and it's 292C. It's headed Principles of Interpretation.
Of the agreement itself.
Correct. These are the principles by which and if you look, please, under retained earnings, which refers to the definition and says if PwC or the auditors advise differently, then and only then would the basis be changed. Now, if you look, please, back at the transcript, B2, page 832. the cross-examination of Mr. Lemaire. And what is there said is that the first question related to the 5.2 million, and Mr. Dar, halfway down, says, then in relation to that question or issue, you said that you understood that PwC had asked for the accounting methodology to be changed. Now that is important, because obviously, if it was the accountants that were revising a departure from the 2010 accounts, then that would be something that Mr. Leese would be able to rely upon. And he says, yes, correct. You say that Ms. Sindhu immediately says it was not PwC, but it was Mr. Leese. Ms. Sindhu is the, one of the partners or one of the employees, senior employees at PwC.
WC
Yeah.
person, okay.
So the point is that if the suggestion came from PwC that resulted in the change, that may put a different perspective on it. But the point is that what was being said here, as we see it from the documents, that it was the suggestion that was coming from Mr. Leese. So, as I say, he was then, according to Mr. Lemaire, invited back after the conversation between Mr. Lemaire and PwC alone to give an explanation. Now, the other point that was taken by my learned friend was that there was an accusation being made of dishonesty, that he was trying fraudulently to obtain the money. Now, if you look at the way that it is pleaded in paragraphs 6.6 and 6.7, which he referred you to, but did not actually take you to, it is dishonesty is not a constituent element, although I accept, as my learned friend pointed out, that in the letter at A20 there was an allegation that this had been done fraudulently. I remind you of the Neary decision that I have taken you to, and in the interest of time I won't do so again, but it's at volume C of, sorry, it's not, it's handed up loose in the authorities bundle, but please have regard to paragraph 20, and I will just read you a short extract from it, if I may. What is there stated by Lord Jauncey was, I am fortified in the view by the decision of the Court of Appeal in Sinclair and Neighbour, where Lord Justice Sellers said, but whether it be described as dishonest misconduct or not, I don't think matters. Views might differ. It was sufficient for the employer, if he could, in all the circumstances, regard what the manager did as something which was incompatible with the duties and the business in which he was engaged. So, making out dishonesty is not a prerequisite. The question is, was the manner in which this was conducted, and the opportunity was then given, so we say, for Mr. Leese to explain what he was doing, having regard to the terms of the SCA, and in particular 9.3, why were we not entitled in those circumstances to take exception with what he did? Now, the judge, when examining this, seems to hive off from the exercise that was being performed without looking at the underlying terms of the SCA and the advantage that would be gained by Mr. Leese. And so what he says at 48 in the first sentence, and why I relied upon it, is is that if the claimant's proposal, and it's the claimant's proposal, not PwC's proposal, was successful, it would go against the previous year accounting methods and inflate the defendant's revenues in the 2013 financial year. I would add words, and would thereby give him a personal benefit which was considerable. That element doesn't seem to be factored into the occasion when considering the manner in which he went about this exercise. That he didn't consider in the round the conduct complained of, but posed isolated questions which don't give the full answer. So the reference, for example, to the claimant's experts, I'm just looking for the paragraph where he addresses those. Forgive me 1 second, please. Can you help me? Where's the representation? I'm sorry, I'm looking for the paragraph, and I'm afraid it's eluding me at the moment, which is a reference to the claimant's expert. That's it. Thank you very much. It's paragraph 45G, page 16 internally. The expert appointed by the claimant concluded that the email exchanges between the claimant and PwC was standard in the context of an audit. But this was done without copying the communication at item B of the revenues that would be generated and included in those accounts to Mr. Lemaire. And the point that I make is that he had a vested interest. That vested interest receives no attention in the comment on letter G and the finding.
Why should it receive comment?
By the judge.
Because it was an incident of Mr. Lisa's position in the company as Chief Financial Officer.
I accept that, my lord, but the point is this. When you are looking at paragraph 48 and the manner in which he went about doing what he did not keep Mr. Lemaire in the picture in respect of the communications at 45B or 45C. And when the judge at 48 makes the finding that he does in that first sentence, he does not then go on to say, and of course the result of doing what he did would be to inflate the account so as to give him a personal benefit. The personal benefit
is a pejorative word.
I beg your pardon?
Inflate implies that he's putting something in which should not be there.
Well, he
That's
uses
a
that
matter on
word.
which we can't make a judgment.
But he uses those words. I'm just
Does.
the judge.
I think he's quoting.
It's
your,
at
your
48.
client.
He uses the word inflate in the third line.
Where's the basis for that?
Basis for that is in all the submissions that have been made, and he doesn't go the
No,
extra.
there is no finding one way or the other whether Mr. Lee's views of the accounts is correct or Mr. Lemaire's view of the accounts is correct. We have no basis for making a finding either way, because that's a whole issue that needed to be tried and settled ultimately in arbitration between your two clients.
Respect, Your Honour, if I can step back and invite you to look at this point, because with respect, the analysis is not correct. Under the terms of the SCA, there would be an adherence to the previous accounting years. If that had happened, those accounts would not include the sums that for the first time Mr. Leese wanted to have included. The judge makes a finding it would go against the previous year's accounting methods.
Which paragraph is this, please?
Paragraph 48. So what he is finding is that what was being proposed by Mr. Leese, who in my submission must be attributed knowledge of the terms of the SCA, particularly they were ones that would benefit him in giving final year's consideration.
So 48 of his judgment?
48, line 2. If the claimant's proposal was...
Not with you, I'm so sorry.
It's internal
I'm always getting mixed up with the wrong 48, so sorry.
All
Yeah,
right.
I'm with you now.
Are you? It's line 2. If the claimant's proposal was successful, it would go against the previous year's accounting methods.
Right, thank you.
And so, under the agreement, there was an adherence to those methods, unless PwC gave advice to the contrary. They did not. He was the person that was driving the change. He drove the change in a way that did not draw the document at 45B or 45C to the attention of Mr. Lemaire, although I accept that the judge finds, and there is an email saying that the topic is one that he is going to be considering with the auditors. But he does
But
not...
sooner or later, it will come to Mr. Lemaire's attention.
Well-
And Mr. Lemaire would be able to deal with it, because that change or that particular accounting policy that Mr. Leese was advocating for could not be accepted by the company unless A, Mr. Lemaire agreed, and B, PwC agreed.
Well, with respect, if PwC agreed and recommended it, then it would have to be adopted in accordance with the principles of
There are
interpretation.
grey areas where it says if you want to take a conservative view, you can do it this way. If you don't, and
But
there
that-
is some
but that
margin
didn't
of
arise.
error.
But the concern that was being raised was that this was being done in the way that it was done, that he was called back to give an explanation, and he behaved in an unacceptable way. And that's when he left
Sorry,
the
he
building.
behaved in an unacceptable way at the meeting of the 11th of February.
A, at the meeting itself, and B, when he left the premises.
But that's a separate cause, or separate exercise or ground. I mean, but in relation to the 5.2 million...
Look at the witness statement, the evidence of Mr. Lemaire. He sets out in detail. As I say, my complaint is that this judgment as to actually what happened at that meeting is pretty silent. And it's key to this sequence of events. It sets out the defendant's case in part only at paragraph 14. And as I say, the point, the paragraph that I've taken you to where there is some extract of the evidence doesn't complete the full answer that appears at paragraph 45D, because it goes ... after no, I don't think he could, and I've taken you to the passage of B802. And so the fact that there was this vested interest and personal benefit by reason of the adoption of this process is simply not considered. And that's why we say that it is necessary to look at the entirety of the conduct in the round against the background of all the material facts and circumstances. And that simply didn't happen.
But am I right to understand that this 5.2 million all goes to the calculation of the retained earnings?
And Mr. Leese gets the retained earnings.
Yes. And the retained earnings is part of the purchase price. Is that correct?
Exactly. So if there had been a successful adoption of 5.2 million, it would have resulted in Mr. Leese receiving that sum.
Can I tell you that I think I've resolved this question that I raised earlier about why is the company a party? The agreement?
Well, it's a party because it relates to the obligations of the employees.
Oh, there's a very peculiar there's a very peculiar concept in including the company in this. It's, if you look at if I take you to the SCA, I'm sorry, I'll give you a few minutes extra
Don't worry.
for this. If you look at 6.2, the whole of clause 6 actually is very strange. because what it says is there are the retained earnings. The retained earnings are defined as something that belongs to the company in the first instance. And then it says Mr. Lemaire assigns and Mr. Lees accepts the assignment of all right, title, and interest in relation to the retained earnings. So from that, I understand that for these years that I mentioned, 2010 onwards to 2013, all of the profits of the company, if the definition of retained earnings, would, regardless of, they were 50-50, weren't they? Up to the time of the sale of the shares?
Yes.
And then after that, although Mr. Lemaire was then 100% owner, still assigned to Mr. Lees effectively all of the profits of the company for those financial years. Then 6.2 says the company acknowledges and agrees to the assignment and agrees to pay the retained earnings directly to Mr. Lees, as set out in 5.2 and 5.3, which I haven't again looked very carefully at the company's law, but in most countries in the Commonwealth, that actually would be an illegal exercise because the company is assisting in the purchase of its own shares. Be that as it may, doesn't enter into, but that's the reason why the company has been included. That's where they, because 6.3 is, everything else is one shareholder or the other using his best efforts to procure certain things to be done by the company.
But with respect, with
just to finish for the record, so that we can get all of this in, and then I'll let you comment if you don't mind. 7.2D, at completion, company shall pay Mr. Lees a sum equal to the retained earnings for the 2010 financial year. All right. Then we go on. And, you know, you were talking about 9.3. So in the context...
Sorry, it's 9.2, not 9.3. It was my mistake, Your Honour.
I'm sorry. No,
misled
both
you.
of them. Yes, 9.2 is simply a covenant between Mr. Lees and Mr. Lemaire as shareholders that they will, and officers of the company, to act in good faith in relation to the management and conduct of the business. And then 9.3 is Mr. Lees continuing as director and can stay on as a director until 31st of December 2014. Now, that clearly is an obligation that's only enforceable between Mr. Lees and Mr. Lemaire.
I disagree.
The company cannot get involved in that.
I absolutely disagree.
Disagree?
And yes, I do. And the reason I say
How,
so...
under company law, can you compel a company to ensure the continuance of the term of a director after its expiry?
No. The point that I'm making about 9.2 is that the company is a party to this agreement. And if you look at Clause 9 and the two schedules, they do more than simply deal with the sale and purchase of shares. But let me finish my submission, and then you can tell me it's rubbish. And in those circumstances, that those obligations are obligations that an employee, each of them, the two senior employees, would owe the company in terms of discharging their obligations. 9.2 contains the standard by which those obligations will be delivered. To whom? The company. Who is a party to the contract? The company as well as the parties. It was our case that was clearly an obligation that was owed by the individuals to the company.
Define the obligation.
The obligation is to act in good faith in relation to the management and conduct of the business. Insofar, insofar...
You need to have an agreement for that obligation. It's under the company's law anyway.
No, it would, as an employee, there is arguably an implicit and implied term of trust and confidence.
Yes.
But this is an express term by reference to duties that are specifically particularized in Appendix 2.
I don't think you heard me right, or you didn't hear me well. I'm saying, what does that add to the position of a director of a company under our company law?
Right. You have to
which expressly provides for all officers, all directors of the company to act in good faith.
Right. There is a clear distinction to be drawn between the role of a director, because a director needn't be an employee. and somebody who fulfills an executive role. The executive role will have contractually, in addition to any fiduciary duties that would otherwise attach to it.
Put aside fiduciary duties at the moment, it's not an issue. The duty of good faith under company law, you are saying is different from the duty of good faith under a common law contract of employment?
The point that I'm making is that
You haven't answered my question.
Well, I'm trying my very best to do it, and if you don't interrupt me, I'll be able to.
Well, you
I'm trying
interrupted
to
me
assist.
earlier, but please
I'm
carry
trying to
on,
assist
Mr.
the
Haughauser.
court. What I'm saying is a contract of employment is one that is separate and distinct from fiduciary duties of a director. What we are looking at here is the termination of a contract of employment when considering Article 59A. This term, in my submission, is imported as a contractual obligation as part of the contract of employment of this gentleman, who was then terminated, we say for cause, under Article 59A. I accept that there is a parallel fiduciary obligation by reason of the fact that he is a director, but you do not terminate somebody's contract of employment other than in accordance with its terms. And you have to ask, what are the terms of the contract of employment by which he is paid his salary and benefits? And that contains terms. Some of them are implied, some of them are express. In the search for the express terms, in my submission, you are driven to look at Clause 9.2. That is my submission.
I'm not sure that we are actually on a different page, Mr. Hwang, just as I don't think I was on a different page from your colleague on the other side. All I'm saying is look at company law first before you get down into employment law. Obviously, one of the implied terms of your contract is you will fulfill your duties as a director of this company under DIFC company law. And unless you say there is a difference between the duty of good faith in the company law from the duty of good faith that's implied in 9.2, in fact, 9.2 can well be taken to be a reference to the company law standard. I don't think you need to worry about it. That's not the real issue. So that if you let me finish my litany of where we finish off with the obligations of the company, it is 12.1 is upon the death of Mr. Lemaire, the company will continue to be bound by the assignment provided in Clause 6. So there are several specific references to the obligations of the company in this agreement, and that's the only purpose of putting the agreement into the company. Nothing turns on the schedules which set out salary packages and employment contracts. These are typical covenants that are agreed between the shareholders, that each of them representing 100% of the shareholders and board of the company will procure for each other. But it's personal covenants with each other. They just use their powers as shareholders, as directors, to ensure that each of them will get the benefits for which they have mutually covenanted. But this is all mechanics. I don't think it really affects the guts of your case. So I don't think you need to be too concerned about that.
All I would say is I stand by the submission I made 5 minutes ago.
So I think the bottom line is that I don't disagree with you on your basic analysis. I just disagree with you of how you get there. But never mind about that. Do you have any other thing to say?
I do.
Try and finish within 5 minutes so that Mr. Novak can have a roughly equal time to respond.
Well, he's only going to respond to the cross appeal, Your Honour.
Yes, please. Go on.
So, could I just deal? I had a couple of other points, if I may. First of all, on the accounts, just to clarify the position, the only amount that was retained in cash from the 5.2 million was 5.4%, and that was refundable in the event that there was not a launch. That money, the 5.2 million, represented principally future and not deferred revenue. And what was being said by Mr. Lees is you should count that in 2013, even though it had not yet been received. That was the issue. In terms of my learned friend's reliance on the Macduff case, could I just explain my submission in this way? There are two aspects that one has to consider. One is applicable in DIFC law and one is not. In relation to this test in UK employment law, is the decision within the reasonable band of reasonable responses? That does not apply in this jurisdiction. It's not could a reasonable employer have decided to dismiss, but would a reasonable employer have dismissed in this case? So, as was pointed out by Justice Giles, it's a tougher test. When considering the reasonable employer, there is a factor that applies in both jurisdictions, and that is in neither the DIFC or in England is a judge entitled to substitute his own view for that of the reasonable employer.
I fully take your point there.
And that was the dictum in Madden. It was not in any way departed from in Macduff. And the reference to the Sainsbury's case is one that relates to paragraph 28 and not paragraph 30 of that decision, because paragraph 30 is concerned with the range of reasonable responses, which was expressly disapproved by Justice Giles in Macduff. He did not in any way suggest that it was permissible for a judge, when looking at the reasonable employer test, to substitute his own judgment for that of a reasonable employer. That is the Madden principle. It has not been affected by the Court of Appeal in this jurisdiction. It is a proper construction and is a helpful indication of the stance to be taken. My learned friend was eliding the 2 points and relying on Macduff for disapproval of them both. It is not authority for that proposition. I invite you to read the relevant paragraphs of Macduff and to look at Sainsbury's in paragraph 28 and in 30, and the fact that Madden, which is the keystone for the dismissal of the subjective test, is nowhere referred to in Macduff at all. So those are my submissions on that, and what my learned friend was doing in his submissions was eliding those two separate aspects. The other point I would make is on Frontline. In Frontline, at paragraph 201, if you read the headnote, it is quite apparent. Well, you know the Frontline case because it came before you on appeal. That it is quite clear that there was, in that case, a consideration that was being put forward that is not tentative at all. Can we just briefly look at paragraph 201? Because I don't suggest, I don't...
Right, 201
of the Frontline case, which is in volume D, I think, at tab 15. This is the first instance decision, of course.
Paragraph?
Right, it's paragraph 201.
Excuse me.
What happened in this case is that one of the parties, in closing, the employer, sought to rely belatedly on Article 59A. And it was refused by the judge. And the reason that it was refused was because the case had already been conducted by then. And what he says is, well, if we were embarking on a Article 59A exercise, that is a different creature to one that is a straightforward breach of contract case. And what he says in the second sentence is, the concept of conduct warranting termination in the article appeals to a standard other than breach of contract or of fiduciary duty, but one which may possibly be wider than either, but in any event can involve a different investigation. And that is my point. Now, what my learned friend says is, well, if you look at Macduff, there is approval that you can, in certain circumstances, look at a contractual test, and it's helpful. Well, it's no answer to the fact that it may throw some light, but it is not the test that the statute provides. And it's the same judge giving his judgment in Macduff in the Court of Appeal as gave the judgment in Frontline. So I find it very difficult to accept the proposition that he was thinking completely differently when he was giving a judgment on behalf of the Court of Appeal in Macduff, compared with that which he was giving only months earlier in Frontline. So those are my submissions, that paragraph 201 is extremely helpful. It was not done obiter. It was part of the rationale for refusing a claimant permission to run a case that was based upon that article. That is not obiter dicta. It is an application that was made within the litigation and which was dismissed. In relation to the reference to the Company Law 2009 and Article 101 as amended in 2013, I make this point. There was no necessity for Mr. Leese to remove the property. As a director, he had a right of access to it. He didn't have to take home the property that belonged to the company, which was returned under protest. First of all, was not returned, and then returned with the data deleted from it. Incidentally, not only was that computer defective of any data, but so was the iPad and the iPhone that was also returned. So this fault that mysteriously happened to 3 electronic devices. And in my submission, one should consider, when looking at the fact that there was a destruction, and it would be necessary for findings to be made by the court, which were not, as to whether or not there was a deliberate destruction, because that informs the motivation for taking the property in the first place. So, for the reasons that I have earlier given, there was no reason to depart from Brando in the way that was done, that there wasn't an application of the correct test, that the matters weren't looked at comprehensively in the round, that the wrong standard was applied, that paragraph 96 is a subjective interpretation rather than an objective interpretation by using the words, in my opinion. And for
said that quite often. Actually, I think we've got the message.
I shall trouble the court no further. Thank you very much.
Thank you.
All Your Honours, can I start with the cross appeal in terms of the daily wage? My learned friend says that it's impossible for us to seen in our supplementary skeleton argument. We deal with this point. You have the authorities in volume D, but I set out the relevant passages at the end of my supplementary skeleton argument. Paragraphs 16 and 17. You have here, first of all, the authority of Crane and Sky and Home Limited. Paragraph 16, page 6 of my supplementary skeleton argument.
Which skeleton is it?
The supplementary skeleton argument.
Yes.
Paragraph 16 is the judgment of Lady Justice Arden in Crane and Sky in Home Limited, where she deals with the circumstances in which a party may raise a new point. And the last point she makes there is, so she says, however, the principle that permission to raise a new point should not be given lightly is likely to apply in every case, save where there is a point of law which does not involve any further evidence and which involves little variation in the case which the party has already had to meet. And you see that she cites there Pitalis and Grant, and that's another Court of Appeal decision, and I set out the relevant passage from Pitalis and Grant in paragraph 17. Even if the point is a pure point of law, the appellate court retains a discretion to exclude it. And this is a pure point of law as to the construction of daily wage. But where we can be confident, first, that the other party has had an opportunity enough to meet it, secondly, that he has not acted to his detriment on the faith of the earlier omission to raise it, and thirdly, that he can be adequately protected in costs, our usual practice is to allow a pure point of law not raised below to be taken in this court. Otherwise, and I would underline this sentence, in the name of doing justice to the other party, we might, through visiting the sins of the advisor on the client, do an injustice to the party who seeks to raise it. The point that is raised in the cross-appeal in relation to the daily wage is a pure point of construction. The is of claim, and we were upfront about this in our application for permission to. The claim was pleaded and presented below on the basis of the basic wage. On the correct construction of Article 18 and daily wage, that is something different. So the fact that those who represented the claimant below the wrong rate, that shouldn't be visited on the claimant in the event that the daily wage is a higher rate. And in this regard, in my submission, it is relevant to take into account that the Article 18 arguments, which of course this court hasn't had to go into ill judgment, but the Article 18 arguments that were pleaded in the grounds of appeal raised a number of new points on the construction of Article 18. The fails. The case below was presented solely on the basis had to read in some kind of a discretion, whereas the ground of appeal on Article 18.2 sought to raise a number of construction points that were not raised below. But in my submission, and His Excellency Justice Muhairi granted permission to appeal on the cross-appeal because he identified that this issue of the correct construction of daily wage is a point of public importance, which is a further reason for this court determining the issue. It is a question of public importance. It doesn't just apply to this case. What is the correct construction of daily wage applies to Article 18.2 more generally, will apply to other cases. And so other people will benefit, other parties, other users, other employers, employees in the DIFC will benefit from knowing what the correct answer is. So in my submission, that is a powerful reason for this court to determine the issue. My submission, that then raises two questions. One is, as a point of principle, what is the correct construction of daily wage? Is it basic wage, as my learned friend said? Our construction of daily wage. Second, having identified the correct construction, how does it apply to the facts of this case? I deal with the first question, what is the correct construction of daily wage? Well, my learned friend took you to the definitions in Authorities Bundle File C. It's tab 2. Sorry, I said tab 2.
For China.
It is, so volume C.
G.
So volume C.
Volume, okay.
Volume C.
Yes.
And it is tab 6. And you recall that the definition section is at starts at page 1268.
Right. I've removed tab 6. Which is it? Is it the employment law?
Yes, it's the Employment Law 4 of 2005.
Yes.
And my friend took you to page 1268. Call. He addressed the question of basic wage, and he pointed out that in basic wage, what it says, basic wage means the employee's wage, excluding. And it's important there to say, so it starts with, it's the employee's wage, but it excluding any portion of an employee's wage received in kind or as, and then you could delete the rest to bonus. So it is saying that it's the employee's wage excluding, for these purposes, bonus. What he then said to you was, so whereas basic wage expressly deals with the bonus, daily wage, 4 boxes down, he said was silent. But actually, when you look at it, as daily wage means the compensation received by an employee, and if I could ask you to underline as wages, because you weren't taken to the definition of wages, as wages for services performed during a working day. And that's important, during a working day, because you've got to work out what is the remuneration, in this case, that Mr. Lees receives when he's doing his day's work. What's the remuneration he's going to receive? The daily wage shall be calculated taking into consideration the total amount of working days in a year, and you'll contrast the end of that tailpiece with the basic wage, which does it by reference to calendar days in a year. So there's a deliberate difference there, which again reflects the fact that we're here looking at remuneration for the work performed. So, wages. So my submission is not silent, the answer is in wages. And when you look at wages, you'll see, over the page 1270, it couldn't be defined more broadly. Wages means all payments made to an employee in return for work done or services provided under the contract of employment. A bonus falls squarely within that definition. Bonus is remuneration, is a payment to the employee in return for work done or services provided under the contract of employment. Pausing there, take the example of fixed figure bonus. Say the contract provided for a £100 bonus. You get a basic salary of X plus a bonus of Y. That's your remuneration structure. There could be no question but that the £100 bonus fell within the definition of wages and therefore falls within daily wages. So the answer to the point in principle that I posed, does daily wage include a bonus, in my submission as a question of principle, it does. And that's why basic wage expressly excludes from the employee's wage a bonus. And the phrase used in Article 18, too, is daily wage, not basic wage.
Where is the term basic wage and daily wage used in this?
Can I take you to Article 18, please? Look at, so page 1250. Article 18.2, it says, if an employer fails to pay wages or any other amount owing to an employee, the employer shall pay the employee a penalty equivalent to the last daily wage. So their daily wage is the defined term that I've shown you. Basic wage is used in the end
That's
of...
the only place it's used?
It's used in other places, but can I give you the end of service, the example of basic wage, because it's quite relevant here.
Yeah.
The end of service gratuity is calculated by reference to the basic wage. That is Article 62. So you can see that the ruler has made the deliberate choice that the extra service gratuity is going to be calculated by reference to the basic wage, whereas Article 18 penalty a penal provision tended to act as a disincentive is calculated by reference to the daily wage. And you'll see, just you asked me where else is daily wage used. Can I just give you the references? Article 28 and also 35. And those are the ones sort of off, just as a quick. But the point is that it's quite clear that the draftsman understands the difference between the two and uses them differently where they are intended to be applied. Maternity pay also is based on daily wage. That's Article 38.
Where do we see that?
Article 38.
28, did you say?
38. Sorry, 28 was compensation of pay, and it was the holiday pay. In lieu of holiday. 35 was sick pay, and 38 was maternity pay. Point being, in my submission, that where the rule uses daily wage is concerned with the actual remuneration, the total remuneration that the person receives for the days, for the working day. And the bonus is a key part of that remuneration, of the compensation. Deal with the...
Sorry, I need to ask you a question. Back to Article 17. Employer shall pay to an employee all wages earned by the employee in a pay period, including vacation pay, at least monthly and within 7 days after the end of the pay period. I don't know whether pay period is defined. Is it? Pay period is defined. 1269.
Hourly, daily, weekly, monthly or yearly period where employees are paid by the hour, day, week, month or year. So it's by reference to what the employer's paid. Or if it's a flat rate,
So
piece rate
let's
concession.
assume.
Can I just refer you to B though, because you'll see it covers other matters. If this is on the pay period, because
I didn't hear you, sorry.
we're reading from the definition of pay period. You read A, but there's also B. If an employee is paid on a flat rate, piece rate, commission, or other incentive basis, the employee's applicable pay period. That just so that we have the full.
I'm not sure that makes any difference because, obviously, in this case, I assume that it's common ground that bonus will be paid at the end of the financial year. So, the pay period, the applicable pay period will be the same period for his normal salary. But what I'm trying to take you back to is, look at Article 17. If the term wages includes bonus, and it says you must pay bonus within 7 days after the end of the pay period, and the pay period is the end of the financial year, does that mean every employer must pay bonus by the 7th of January?
Must mean if the bonus is this is talking about all wages earned by the employee in a pay period, and must mean in respect of the bonus that if the bonus is at the point of termination, if there is a bonus that is payable, i.e. that the time for payment has arisen, then that bonus must be paid in. If there is a bonus payment outstanding at that point of termination, it must be paid within.
This has nothing to do with termination. This is just your regular employee who's continuing from year to year. So what it seems to say is that all wages shall be paid within 7 days after the end of the pay period, which is the particular period when payments of this nature are being made. So with the salary, within 7 days after the end of the month, let's say. Bonus, it depends.
As to what the
obviously, if the
provides.
bonus is declared before the end of the calendar year, then you pay him, within 7 days of that. But in this case, where bonus is not determined for several months after, when are you supposed to pay?
Oh, so there you'd pay the bonus within 7 days of when it becomes payable. So in this
But
case,
that's not what it says, does it?
well, if you read that in conjunction with the definition of pay period in terms of B, sub B,
An employee is paid not on a flat rate, not piece rate, not commission, or other incentive basis. The employee's applicable pay period. The pay period is the period for which he's supposed to work. When he's finished his work, he's supposed to get his bonus. Now, does this imply that under Article 17, bonus must be paid by 7 days after the end of his working year?
that can
Because
be
this might affect the interpretation that you are putting on Article 18 in relation to bonus.
correct. In my submission, that wouldn't be right because the daily wage is daily wage is expressed. The express term used means the compensation received by an employee as wages. Wages is the defined term, which we see at page 1270, which says it means all payments made to an employee in return for work done or service provided under the contract. And a bonus falls squarely within that definition.
It's actually not a very good definition because it talks about payments made. So by the time it's made, the obligation has disappeared. I mean, it's self-fulfilling. It should say all payments payable to an employee.
With respect, that's, in my submission, is clearly the meaning of when it says all payments made. When it defines wages, it must be, when it says made, it must mean payable for it to have any sense in terms of
But
genuine.
in this case, I think, wasn't it expressly payable quite late after the end of the working year?
Yes, it was.
So,
Yes.
either you've got to
Oh,
make
but
sense of it, or you say that that particular arrangement was illegal.
With respect, that analysis would, if your honour is correct, that would also apply to normal basic salary. In terms of the basic salary wouldn't fall within all payments made. So if the employer doesn't,
That's why I say it's a
pay-
bad definition.
Yes, exactly. Which is why with respect,
You're trying to make sense of it.
otherwise it would knock out.
But the difference is still this. In the case of the monthly wage, which is your paradigm, normally the date on which your right to that salary accrues would be after the last day of the month. All right? So this Act says within 7 days you've got to pay the wage. That's the sensible way of interpreting this. But where the date of accrual is not the end of the working year, as with bonus, many companies' bonus are declared, after a month. Sometimes it's staggered over a period. It's conditional upon certain other events happening. Then you need to have a flexible definition to cover bonus. And because this Article 18 doesn't have any flexibility in it, doesn't that give rise to the argument that because it's defined in this rather fixed way, it's meant to apply really to fixed periodic payments rather than bonus, which is an add-on, which doesn't have to abide by any particular rules as to time.
With respect, that depends. Even on that analysis, that would depend on that was paid annually.
Most bonuses are paid annually.
So
They don't have to be paid right at the end of the year.
But I'm positing the situation whereby the contract provides for a bonus to be paid on the. That's the bonus. Yes, you got the 5th of April. You'll be that bonus in Your Honour's example.
But the sensible interpretation of any law would be that the obligation to pay the bonus should be within a fixed period of the day when the bonus first became due. And when it becomes due is a matter of contract between employer and employee. If they choose to defer the accrual date of the bonus until a later time, then the obligation to pay has to be adjusted to take care of that. Because this particular phraseology doesn't seem to allow for that, I'm saying that is there therefore an argument that it was not intended to cover bonus?
My submission, if that was correct, then they had the definition. Basic wage. As in the extra security, basic wage.
No.
Therefore, had that been the intention, they had the tool available, which they've used elsewhere, and they've expressly used daily wage. A daily wage, and with respect, Your Honour, you were quite right to say, well, where else does it apply? Because it's not just in respect of Article 18. So your construction, and so whilst the temptation may be to construe daily wage in a limited fashion because of the Article 18 consequence, relevant that daily wage is not only used in other important contexts, maternity pay, sick pay, holiday pay, and so therefore it would not, in my submission, be right to limit the construction of daily wage because of the consequences of Article 18, because that will then have its own consequences for, as I say, other important statutory rights that has deliberately used daily wage, not basic wage.
Sorry, I lost the flag for daily wage. Just show me the sections again.
1268.
1268. Huh?
Is this the definition you're asking for, or
No, the usage of.
so the uses are so it was Article 18. Sorry.
28. Ah, sorry, I didn't pick it up earlier. Section 28, is it? Article 28.
There's also, I don't know if we referred to it. Did I also
Okay,
say,
that's right.
did I also say 32,
all of these-
32.2 as well?
Daily wage is used when you are computing a particular employment benefit the government has deemed fit.
Yep.
that shall be. So it's the basis of a mathematical
Yes.
formula. Whereas Article 18 is about enforcement. It's about your obligation to fulfill, your duties, either contractual, well, in fact, basically contractual.
It's the consequences of you failing.
Yeah, so
to-
the test need not be the same. I mean, they might not use daily wage here.
Sorry, Your Honour, if you're suggesting that you could daily wage a different meaning in, depending on whether you're applying it in Article 18 or Article 35, 28 and 32, well, in my submission, that is just impermissible. You can't construe the same term, which is a defined term, differently in the same chapter.
No, I'm saying we use the same word differently in different sections because the term we are concerned with is wages, not daily wage. You are saying wages in Article 18 means the daily wage. I'm not saying that
No,
there is
with-
any difference in the usage of daily wage. Oh, sorry, you're looking at 18.2, are you?
I'm saying is that it would be daily wage in Article 18.2.
But before
have
you
it-
get to the last daily wage, you have to pass the gateway. The gateway is if he fails to pay wages. That's the word I'm fixing on.
Yes, but
In other words,
yeah.
on the 7th of January 2014, they had not been in breach of 18.2 because the bonus was not known. You can't pay a figure
But we're
which
not.
is not.
But we're not relying on the non-payment of a bonus for the breach of the Article 18.1 obligation.
What are you relying on, please? I'm sorry, I thought the whole idea was to make the penalty applicable to the bonus as well. No? Have I misunderstood you?
Sorry, with respect, I think it must be my mistake, but there are two different questions in Article 18. Article 18.1 is the obligation. The obligation is to pay all sums owing on termination within the defined period, 14 days. If you fail, and then Article 2 tells us, if you do not meet that obligation, so that doesn't, the bonus is irrelevant for these purposes. If you do not meet that obligation, the consequences are that you shall pay a penalty, and that penalty is quantified not by reference to what you failed to pay the wages in Article 18.1. The ruler has decided that that will be quantified by reference to the employee's daily wage.
Yes, but before you quantify it, you have to impose an obligation. It only arises if you are in breach of your obligation.
There's
The
no
obligation
dispute. Absolutely.
is to pay all wages and other amount owing within 14 days after termination. But is that a wage must include surely, well, not surely, but arguably, an amount which is actually owing. If it's not owing, then you can't pay pay by termination date.
No dispute there. Absolutely. But having failed to do so,
Do what?
to pay the wages...
This is why it becomes so disproportionate and what the objection
That's
to your particular measure of default.
That's why I referred you earlier to the tax case.
Tax case, yeah. No, but it's a different one.
It was exactly the same issue. You had a tax penalty that was 3 times not the under-assessment, 3 total tax that you paid in that, or that was charged for in that year. So you could have a £1 million tax liability that you'd under-assessed by £1, yet the penalty was charged 3 times, not by 3 times by the £1 under-assessment, but 3 times the £1 million liability. So you would get a £3 million liability for a £1 under-assessment.
But my point is nothing to do with proportionality here.
I was answering...
I'm so sorry, yes,
I was answering...
but my point is really...
That is the point, isn't it? Because the measure that you have to pay
Exactly.
you have to then look at whatever
That's...
you say. We're stuck with the definition, and that's that.
is a defined term which is used in relation to other important statutory benefits. Those are my submissions on the issue of principle as to what a daily wage is. Can I address then the issue of what I described as the second issue? How does that apply to the facts of this case? The facts of this case are that when you look at Appendix 2, bonus was a key element of the claimant's remuneration for the work he performed. It therefore falls within definition of wages and therefore daily wage. You then have the question, well, if his daily wage included a bonus, how do you deal with the situation? Bonus for the 2013 year wasn't quantifiable or payable until a later date. Well, you have a number of options. One option is you look at because there's no doubt that it is that actual remuneration includes the bonus. Now, there are a number of ways in my submission. First of all,
While you're looking at that, just show me the page in the contract where it deals with the bonus.
It's Appendix 2, so it's tab 15 and it's Appendix 2. I think we can put away, volume 2.
Appendix 2, is it? The one for Mr. Lee's, right?
Yes. So you've got both of them, Mr. Lemaire and Mr. Leeds.
Okay, got it. No, you please carry on. I've got it.
So can I just give you so when you look at, bearing in mind it's only the 2013 year that gives you the quantification difficulties. Look at the previous years, the sums are 50% of salary.
Yeah, but we are talking about 2013.
2013 bonus was the one that wasn't quantifiable yet. In my submission, the simple answer to this, an answer to this would be, were to say, well, meant to be the difficulty because the 2013 bonus wasn't quantifiable, well then the obvious thing to do would be to look at, as at the point of termination, you might say, well, we don't know what 2013 is, but we do know what the previous 2 or 3 years were. It was 50% of salary. Because that is the fairer result in circumstances where, and I say...
The point doesn't arise, does it? And the difficulty that occurs that you can't calculate doesn't matter here, because until you've assessed the bonus, you're not going to be that problem, which I'm trying to grapple with, is that you're in arrears of something else, and you just get this disproportionate...
This is where in my submission
well, no one's suggesting he's not getting paid this for his work, so I mean, it's only a question of quantification and when you can quantify it.
exactly, but
No.
to sit expressly said that those other areas, well, what is this employee's daily wage? And so...
But it really doesn't matter, save in the context of Article 18. Because you're not getting a penalty that arises. At the end of the day, for any period of sick leave, maternity, holiday pay, whatever, come the time, you can go back and pay the relevant amount.
Not necessarily. Or is not yet quantifiable. The ruler has determined that you are entitled basic wage, but by reference to your daily. Therefore, how do you implement the ruler's intention? If I can't quantify the future.
So you can't do that.
Ex post facto.
Or you do it ex post facto, yes.
That's my point.
Sorry,
it doesn't matter, save in the Article 18 context.
But our problem is in Article 18 context.
Article 18.
But the answer to your Article 18 question would also, though, has an impact on those other important rights, which is an important reason why one shouldn't bend or seek to twist the Article 18 meaning, because it will impact on other vulnerable individuals' rights that the ruler has intended to give them. So that is the point of principle on the quantum. Can I just briefly say on the interest point? I know a friend relied on the interest on judgment, but this is about judgment debts. But it's about interest on judgment debts. We're not talking about interest on judgment debts, and we address this in our skeleton argument. We're dealing
But
here.
it is still a discretionary remedy. Pre-judgment, just the same. In fact, a fortiori, because you don't have a judgment act type of rate, do you?
Save that, the bylaws expressly provide and I can get, it's in our skeleton argument, can I just give you the reference? It's volume C, tab 2, page 1199, article 17 of the law of damages deals with the interest payable where a sum, where a party has failed to pay a sum. And that provides for interest to run, not like judgment debts from the date of judgment. As you'd expect, it's the payment runs from the date that the payment was payable. And so that's what we say is the applicable one, and that's where you get this reference to the average prime borrowers, the lender's rate to prime borrowers.
I mean, but the short point was that it's complete. The judge did not have to award IBOR plus.
But he should give reasons though for the. There we are. Can I just make the following short points, which I can make in bullet point form, very, very briefly.
Such other sums, no? I don't have it.
Rate of interest shall be the average bank.
Yes. We could find. We've looked and because we also saw the practice direction relied on by my learned friend. That was obviously inapplicable because that's referring to judgment debts. This quoted in our skeleton argument. Relevant Article 17 provision.
Just reading it on its own, and
Right, which law are you quoting?
page 111.
There's the law of damages and remedies. C2. Volume C, tab 2.
1198.
1199.
This is the damages.
8% being put forward.
My assumption is not.
I think not.
My assumption is
Sounds
not.
high.
And we also get into the point about.
Also, my lords, I don't believe it would apply to the penalty, because that would not be, that would be by reason of the order of the court.
Then again,
It
you have
applies
to,
when a sum of money falls due.
Well, with respect though, the point actually falls due because it's not article point made by Ms. Justice. And friends,
That's why he found a median rate of interest.
yeah, exactly, and wording that makes it court 82 finds that it exactly, and what the court is doing, and dealt with by Mr. Justice Giles, he is simply saying that if you don't pay it, you bring that debt which has already arisen. It's as every not. Again, we go back in that context. It goes back to 18.2. So that judgment debt does not apply.
Well, when I died, I would always ask for evidence about what the
And with respect, a way of this being dealt with is for an The problem is it's not published correctly. As with so many things, that's probably more
Optimistic.
Can I please just raise four, just some short points of correction, please? My learned friend said that of what Mr. Lemaire knew. He said Mr. Lemaire didn't know about the 5.2 million figure, but you've got 45D. Various people, including Mr. Lemaire. Look over the page, it's set out. They expressly raised that 5.2 million. Reference. It's at the top of page 58.
Right. What are you referring to now?
We're in the judgment.
Judgment?
My friend said that Mr. Lemaire didn't know about the 5.2 million figure until the 11th of February. But the point of correction, at the bottom of page 57, it's page 14 of the internal pagination of the judgment. It's 45D. Email on the 2nd of February 2013, PwC sent the claimant, Mr. Lemaire, etc. And you'll see the attachment over the page. £5.2 million of revenue. Recall the cross-examination that I took you to this morning, whereby Mr. Lemaire said that he formed the conclusion 10 days in advance of February that the claimant was seeking to fraudulently the figures. Second point of correction, my learned friend said that the defence didn't plead. I ask you when you're doing your reading just to look at paragraph 6.9 and paragraph 7 of the defence. Whilst the word fraud isn't used, my submission on a fair reading of paragraph 6.9, paragraph 7 of the defence, that is what is being alleged. 17th of April letter, which expressly raises fraud.
What's only important insofar as it would affect your client's reaction?
But yes, yes. So it goes to the, but it also, yes. It all, you've then got, well, sorry, it is, but it's also relevant to the finding about haphazard, arbitrary, unjustified assessment of or conclusion of fraud. The next point is that...
but it's only relevant if the employer was going to make use of those beliefs to mount some kind of assault against your client. Right? He had reasonable cause to take defensive measures. That's your case.
Just on that point, raised this morning the point about the complaint that was made by prosecutor. That's something that the court would like to see.
Well, was it in evidence? It's not been referred to in any of your skeletons.
With respect, in our supplemental skeleton argument, we make...
I take it.
Although this would have been after the termination, so strictly speaking, it is a collateral matter, isn't it?
The reason for referring it to you there, when he was dealing, there was no specific regulatory, and he referred that subsequent to the termination and up to the date of trial, there had been no regulatory issues that had arisen. And if you recall, I was making the point that couldn't be further from the case in our case.
I can't...
I'm sorry, I thought in the Brando case, I mean, the regulatory issue would be if this person was responsible and was thinking that he or she would be accountable to some regulatory authority. That was the motivation for keep taking copies of relevant documents. In case there was some regulatory inquiry, so you would have to argue that your client had some belief, that a reasonable belief that there might be some inquiry by, in this case, the police or equivalent authority.
References in the closing supplementary. That was the case advanced. The reference to the opening submissions, and the judge cites it as well, sets it out in the judgment. The other point on terms of documents was you asked the question earlier, which I don't think anybody's come back to, asking earlier about evidence in relation to the accounts. Asking that you wanted to understand the underlying issues.
How should I put it? Would each of the expert reports have an executive summary?
Well, there is the joint statement in which the joint report in which the judge raises questions and the two experts give their respective answers.
Just to get a little bit of the flavour without going into the detail of it.
I'm told the joint report. I'm told it's 8 pages.
That might be.
It was just in answer to your
Why
question.
don't you send it to us later on?
Can I just give you a reference, my learned friend, in relation to the 11th of February? He's told you what the claimant said, what the defendant said about the 11th of February meeting. Can I just give you these two references? The defence, paragraph 6.7, so this is about what took place at the 11th.
6.7 of what, sorry?
Of the defence, because you'll see that there is this point about coming back is not in, is a very different account. And also paragraphs 106 to 110 of the claimant's witness statement, volume D, tab 7, page 1581. Volume D, tab 7, page 1581. Paragraphs 106 to 110. Then a friend raised a point where he said about the accounts and the that's disputed, it's not. Instructions, he was saying.
But what is my learned friend's case? If he's got instructions, what are they?
What's the point in issue?
My learned friend, just shortly before he sat down, stood up and said what he said, nice figures as to what he said the cash was that was retained. 5.77.
5.4 was the...
Right, my learned friend has put that figure 2 minutes before he sat down. All I'm doing is seeking to say that we had our primary submissions beforehand, and the final point I just wanted to raise was everything that my learned friend said about the accounts and how it was inappropriate because of the SC8 asked the question. The paragraph that he has not...
Well, I'm sorry, this cannot be a reply, a further reply to my...
Not if my plane's going to leave. Please sit down, Mr. Hockhauser.
Paragraph 45E. Accepted. Correct. And nothing wrong with Mr. the claim asking PwC the questions about the...
This is the cross-exam you showed us earlier.
But it's the judge's finding as well. What was the finding of fact made by the judge recorded in 45E? Can I just check to see if there's anything... I'm very grateful for...
What was the point you wanted to address, Mr.
The only other point I had to raise was this. Reference was made to the other articles in the employment law in which daily wage is calculated. When one looks at that in terms of sick pay, for example, or holiday pay, the idea that you would incorporate within that a bonus, for example, if you have a right to a discretionary bonus, that isn't even considered at a date into the future and may not be awarded at all, it is impossible to see how the ruler intended, when somebody goes off for a week's sickness, for example, that that should contain an element of a bonus payment that may or may not materialize at some point in the future. And the idea that one would make a retrospective payment, frankly, is unrealistic. Within this jurisdiction, the idea that when an employee goes off on a sick payment or on sick leave to receive the payment that they will get it within, obviously, a month or a week of them falling sick. And the calculation will be made on the sums that were payable at the time that they go off. And the idea here that you have a bonus yet to be calculated, which is within a band, within over 18 months hence from the date of departure, that can somehow retrospectively be incorporated. For example, if the employee...
Yeah, but you see, you know, that assumes that there's some perfect logic in this whole structure.
Well,
and what
can I complicate it
grappling
further?
with is that if you fall foul of, you know, your payment obligations in any way, then the penalty is totally disproportionate. And if that is the basis that they want to throw the book at you, then all sorts of things can go in.
Well, let me posit this question. Suppose you pay within 2 weeks and the bonus is not calculated for 18 months. Would you have to pay in respect of a bonus that you don't even know the amount of in order to satisfy the penalty? How is that possible?
If you delayed your bonus for 18 months, there'll be a separate cause of action, you know. And
Well, no, but when you are paying, suppose you don't pay the correct penalty. I mean, how do you calculate that? You know, if you get rid of this obligation within a fortnight of falling foul of it, the bonus is months into the future. You have no idea what it's going to be, and you pay your penalty. How do you calculate it if you get rid of that obligation in a fortnight?
no, I
How's it
understand. I think that point, you know, we were already ahead of you on that, I think. Thank you very much. If there's nothing else... Oh, one last question, Mr. Hockhauser, and please 2 minutes. There's one question. I know you can give a whole lecture on this. To what extent should
I promise I won't.
Yes. To what extent should this court accept and apply without reservation the English authorities that you have been citing, which are based on a law of unfair dismissal, which does not exist in the DIFC?
Well, as the learned judge says, he posits at the beginning that in essence this case is about unfair dismissal. That's what he says in the opening sentence of paragraph 20. And
Paragraph 20.
Yes, it's paragraph 20 at page 9 of the judgment.
Yes.
So he uses that expression, and I accept that it's used loosely and not in the sense of the DIFC law. But the considerations of a reasonable employer and the objective test that has been propounded in my submission would supply a lot of guidance to the court in adopting the correct approach.
Then, huh?
That's my submission.
Thank
No
you.
lecture.
Thank you. Obliged to counsel, well, we are all obliged to counsel for their very assiduous assistance. We will get back to you. As I said, there is a technical, not technical, but there is a practical issue here that the frontline judgment is still being written. I will have to think about what is the fairest way of dealing with this, whether we have two parallel judgments and one will come first. If the frontline judgment comes out first, definitely we will give it to you for final comment, or whether we should actually, there are, as you say, common judges on this panel, in the other panel, and whether or not we should actually look at some of the submissions in this case that you've advanced and throw them out to counsel in the other one, and perhaps then have one judgment on this Article 18.2 point. We'll work that out and keep you informed.
So presumably, if you require further submissions from us,
Yes.
the court will notify us of that.
I think it's very likely that we will, one way or the other, but how exactly we will fashion that request to you, I will discuss with the other judge in the other case. Very much.
All rise.
What I will do is, if I can